M. Laxmikanth, Indian Polity. Chapter 33. State Legislature. The state legislature occupies a preeminent and central position in the political system of a state. Articles 168 to 212 in Part 6 of the Constitution deal with the organization, composition, duration, officers, procedures, privileges, powers and so on of the state legislature. Though these are similar to that of Parliament, there are some differences as well. Organization of state legislature. There is no uniformity in the organization of state legislatures. Most of the states have an unicameral system, while others have a bicameral system. At present, 2019, only 6 states have 2 houses, bicameral. These are Andhra Pradesh, Telangana, Uttar Pradesh, Bihar, Maharashtra and Karnataka. The Jammu and Kashmir Legislative Council was abolished by the Jammu and Kashmir Reorganization Act, 2019. The Tamil Nadu Legislative Council Act, 2010 has not come into force. The Legislative Council in Andhra Pradesh was revived by the Andhra Pradesh Legislative Council Act, 2005. The 7th Amendment Act of 1956 provided for a legislative council in Madhya Pradesh. However, a notification to this effect has to be made by the President. So far, no such notification has been made. Hence, Madhya Pradesh continues to have one house only. The 22 states have unicameral system. Here, the state legislature consists of the governor and the legislative assembly. In the states having bicameral system, the state legislature consists of the governor, the legislative council and the legislative assembly. The legislative council, Vidhan Parishad, is the upper house, second chamber or house of elders, while the legislative assembly, Vidhan Sabha, is the lower house, first chamber or popular house. The Constitution provides for the abolition or creation of legislative councils in states. Accordingly, the Parliament can abolish a legislative council where it already exists, or create it where it does not exist, if the Legislative Assembly of the concerned state passes a resolution to that effect. Such a specific resolution must be passed by the State Assembly by a special majority, that is, a majority of the total membership of the Assembly and a majority of not less than 2/3 of the members of the Assembly present and voting. This Act of Parliament is not to be deemed as an amendment of the Constitution for the purposes of Article 368 and is passed like an ordinary piece of legislation, i.e., by simple majority. The idea of having a second chamber in the states was criticized in the Constituent Assembly on the ground that it was not representative of the people, that it delayed legislative process, and that it was an expensive institution. Consequently, the provision was made for the abolition or creation of a legislative council to enable a state to have a second chamber or not according to its own willingness and financial strength. For example, Andhra Pradesh got the Legislative Council created in 1957 and got the same abolished in 1985. The Legislative Council in Andhra Pradesh was again revived in 2007 after the enactment of the Andhra Pradesh Legislative Council Act, 2005. The Legislative Council of Tamil Nadu had been abolished in 1986 and that of Punjab and West Bengal in 1969. In 2010, the Legislative Assembly of Tamil Nadu passed a resolution for the revival of the Legislative Council in the state. Accordingly, the Parliament enacted the Tamil Nadu Legislative Council Act, 2010, which provided for the creation of Legislative Council in the state. However, before this act was enforced, the Legislative Assembly of Tamil Nadu passed another resolution in 2011 seeking the abolition of the proposed Legislative Council. Composition of 2 houses. Composition of Assembly. Strength. The Legislative Assembly consists of representatives directly elected by the people on the basis of universal adult franchise. Its maximum strength is fixed at 500 and minimum strength at 60. It means that its strength varies from 60 to 500 depending on the population size of the state. However, in case of Arunachal Pradesh, Sikkim and Goa, the minimum number is fixed at 30, and in case of Mizoram and Nagaland, it is 40 and 46 respectively. Further, some members of the legislative assemblies in Sikkim and Nagaland are also elected indirectly. Nominated member. The governor can nominate one member from the Anglo-Indian community if the community is not adequately represented in the assembly. Originally, this provision was to operate for 10 years, i.e., up to 1960. But this duration has been extended continuously since then by 10 years each time. Now, under the 95th Amendment Act of 2009, this is to last until 2020. Territorial constituencies. For the purpose of holding direct elections to the Assembly, each state is divided into territorial constituencies. The demarcation of these constituencies is done in such a manner that the ratio between the population of each constituency and the number of seats allotted to it is the same throughout the state. In other words, the Constitution ensures that there is uniformity of representation between different constituencies in the state. The expression population means the population as ascertained at the last preceding census of which the relevant figures have been published. Readjustment after each census. After each census, a readjustment is to be made in the A. Total number of seats in the assembly of each state and B. The division of each state into territorial constituencies. The Parliament is empowered to determine the authority and the manner in which it is to be made. Accordingly, Parliament has enacted the Delimitation Commission Acts in 1952, 1962, 1972 and 2002 for this purpose. The 42nd Amendment Act of 1976 had frozen total number of seats in the assembly of each state and the division of such state into territorial constituencies till the year 2000 at the 1971 level. This ban on readjustment has been extended for another years, i.e., up to year 2026, by the 84th Amendment Act of 2001 with the same objective of encouraging population limiting measures. The 84th Amendment Act of 2001 also empowered the government to undertake readjustment and rationalization of territorial constituencies in a state on the basis of the population figures of 1991 census. Later, the 87th Amendment Act of 2003 provided for the delimitation of constituencies on the basis of 2001 census and not 1991 census. However, this can be done without altering the total number of seats in the assembly of each state. Reservation of seats for SCs and STs. The Constitution provided for the reservation of seats for scheduled castes and scheduled tribes in the assembly of each state on the basis of population ratios. Originally, this reservation was to operate for 10 years, i.e., up to 1960. But this duration has been extended continuously since then by 10 years each time. Now, under the 95th Amendment Act of 2009, this reservation is to last until 2020. Composition of Council. Strength. Unlike the members of the Legislative Assembly, the members of the Legislative Council are indirectly elected. The maximum strength of the Council is fixed at 1/3 of the total strength of the Assembly and the minimum strength is fixed at 40. It means that the size of the Council depends on the size of the Assembly of the concerned state. This is done to ensure the predominance of the directly elected House Assembly in the legislative affairs of the state. Though the Constitution has fixed the maximum and the minimum limits, the actual strength of a council is fixed by Parliament. Manner of election of the total number of members of a legislative council. 1/3 are elected by the members of local bodies in the state like municipalities, district boards, etc. 2/112 are elected by graduates of 3 years standing and residing within the state. 3/112 are elected by teachers of 3 years standing in the state, not lower in standard than secondary school. 4/1/3 are elected by the members of the Legislative Assembly of the state from amongst persons who are not members of the Assembly, and 5. The remainder are nominated by the governor from amongst persons who have a special knowledge or practical experience of literature, science, art, cooperative movement and social service. Thus, 5/6 of the total number of members of a legislative council are indirectly elected and 1/6 are nominated by the governor. The members are elected in accordance with the system of proportional representation by means of a single transferable vote. The bona fide or propriety of the governor's nomination in any case cannot be challenged in the courts. This scheme of composition of a legislative council, as laid down in the Constitution, is tentative and not final. The Parliament is authorized to modify or replace the same. However, it has not enacted any such law so far. Duration of 2 houses, duration of assembly. Like the Lok Sabha, the Legislative Assembly is not a continuing chamber. Its normal term is 5 years from the date of its first meeting after the general elections. The expiration of the period of 5 years operates as automatic dissolution of the Assembly. However, the governor is authorized to dissolve the Assembly at any time, i.e., even before the completion of 5 years, to pave the way for fresh elections. Further, the term of the Assembly can be extended during the period of national emergency by a law of Parliament for 1 year at a time, for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. This means that the Assembly should be re-elected within 6 months after the revocation of emergency. Duration of Council. Like the Rajya Sabha, the Legislative Council is a continuing chamber, that is, it is a permanent body and is not subject to dissolution. But 1/3 of its members retire on the expiration of every second year. So, a member continues as such for 6 years. The vacant seats are filled up by fresh elections and nominations by governor at the beginning of every 3rd year. The retiring members are also eligible for re-election and renomination any number of times. Membership of State Legislature. 1. Qualifications. The Constitution lays down the following qualifications for a person to be chosen a member of the state legislature. A. He must be a citizen of India. B. He must make and subscribe to an oath or affirmation before the person authorized by the Election Commission for this purpose. In his oath or affirmation, he swears 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. C. He must be not less than 30 years of age in the case of the Legislative Council and not less than 25 years of age in the case of the Legislative Assembly. D. He must possess other qualifications prescribed by Parliament. Accordingly, the Parliament has laid down the following additional qualifications in the Representation of People Act, 1951. A. A person to be elected to the Legislative Council must be an elector for an assembly constituency in the concerned state, and to be qualified for the governor's nomination, he must be a resident in the concerned state. B. A person to be elected to the Legislative Assembly must be an elector for an assembly constituency in the concerned state. C. He must be a member of a scheduled caste or scheduled tribe if he wants to contest a seat reserved for them. However, a member of scheduled castes or scheduled tribes can also contest a seat not reserved for them. 2. Disqualifications. Under the Constitution, a person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state. A. If he holds any office of profit under the union or state government, except that of a minister or any other office exempted by state legislature. B. If he is of unsound mind and stands so declared by a court. C. If he is an undischarged insolvent. D. If he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance to a foreign state. And E. If he is so disqualified under any law made by Parliament. Accordingly, the Parliament has prescribed a number of additional disqualifications in the Representation of People Act, 1951. These are similar to those for Parliament. These are mentioned here. 1. He must not have been found guilty of certain election offences or corrupt practices in the elections. 2. He must not have been convicted for any offence resulting in imprisonment for 2 or more years. But the detention of a person under a preventive detention law is not a disqualification. 3. He must not have failed to lodge an account of his election expenses within the time. 4. He must not have any interest in government contracts, works or services. 5. He must not be a director or managing agent nor hold an office of profit in a corporation in which the government has at least 25% share. 6. He must not have been dismissed from government service for corruption or disloyalty to the state. 7. He must not have been convicted for promoting enmity between different groups or for the offense of bribery. 8. He must not have been punished for preaching and practicing social crimes such as untouchability, dowry and sati. On the question whether a member has become subject to any of the above disqualifications, the governor's decision is final. However, he should obtain the opinion of the Election Commission and act accordingly. Disqualification on ground of defection. The Constitution also lays down that a person shall be disqualified for being a member of either house of state legislature if he is so disqualified on the ground of defection under the provisions of the 10th schedule. The question of disqualification under the 10th schedule is decided by the chairman in the case of Legislative Council and Speaker in the case of Legislative Assembly and not by the governor. In 1992, the Supreme Court ruled that the decision of Chairman-Speaker in this regard is subject to judicial review. 3. Oath or affirmation. Every member of either house of state legislature, before taking his seat in the house, has to make and subscribe an oath or affirmation before the governor or some person appointed by him for this purpose. In this oath, a member of the state legislature swears a. To bear true faith and allegiance to the Constitution of India. B. To uphold the sovereignty and integrity of India and C. To faithfully discharge the duty of his office. Unless a member takes the oath, he cannot vote and participate in the proceedings of the House and does not become eligible to the privileges and immunities of the state legislature. A person is liable to a penalty of 500 rupees for each day he sits or votes as a member in a house. A. Before taking and subscribing the prescribed oath or affirmation, or B. When he knows that he is not qualified or that he is disqualified for its membership, or C. When he knows that he is prohibited from sitting or voting in the House by virtue of any law made by Parliament or the state legislature. Members of a state legislature are entitled to receive such salaries and allowances as may from time to time be determined by the state legislature. 4. Vacation of seats. In the following cases, a member of the state legislature vacates his seat. A. Double membership. A person cannot be a member of both houses of state legislature at one and the same time. If a person is elected to both the houses, his seat in one of the houses falls vacant as per the provisions of a law made by the state legislature. B. Disqualification. If a member of the state legislature becomes subject to any of the disqualifications, his seat becomes vacant. C. Resignation. A member may resign his seat by writing to the chairman of Legislative Council or Speaker of Legislative Assembly, as the case may be. The seat falls vacant when the resignation is accepted. D. Absence. A house of the state legislature can declare the seat of a member vacant if he absents himself from all its meeting for a period of 60 days without its permission. E. Other cases. A member has to vacate his seat in the either house of state legislature. 1. If his election is declared void by the court. 2. If he is expelled by the house. 3. If he is elected to the office of president or office of vice president, and 4. If he is appointed to the office of governor of a state. Presiding officers of state legislature. Each house of state legislature has its own presiding officer. There is a speaker and a deputy speaker for the legislative assembly, and a chairman and a deputy chairman for the legislative council. A panel of chairmen for the assembly and a panel of vice chairmen for the council is also appointed. Speaker of Assembly. The speaker is elected by the assembly itself from amongst its members. Usually, the speaker remains in office during the life of the assembly. However, he vacates his office earlier in any of the following three cases. 1. If he ceases to be a member of the assembly. 2. If he resigns by writing to the deputy speaker, and 3. If he is removed by a resolution passed by a majority of all the then members of the assembly. Such a resolution can be moved only after giving 14 days advance notice. The speaker has the following powers and duties. 1. He maintains order and decorum in the assembly for conducting its business and regulating its proceedings. This is his primary responsibility, and he has final power in this regard. 2. He is the final interpreter of the provisions of A. The Constitution of India, B. The rules of procedure and conduct of business of assembly, and C. The legislative precedents within the assembly. 3. He adjourns the assembly or suspends the meeting in the absence of a quorum. 4. He does not vote in the first instance, but he can exercise a casting vote in the case of a tie. 5. He can allow a secret sitting of the House at the request of the leader of the House. 6. He decides whether a bill is a money bill or not, and his decision on this question is final. 7. He decides the questions of disqualification of a member of the Assembly arising on the ground of defection under the provisions of the 10th Schedule. 8. He appoints the chairman of all the committees of the Assembly and supervises their functioning. He himself is the chairman of the Business Advisory Committee, the Rules Committee and the General Purpose Committee. Deputy Speaker of Assembly. Like the Speaker, the Deputy Speaker is also elected by the Assembly itself from amongst its members. He is elected after the election of the Speaker has taken place. Like the Speaker, the Deputy Speaker remains in office usually during the life of the Assembly. However, he also vacates his office earlier in any of the following three cases. 1. If he ceases to be a member of the Assembly. 2. If he resigns by writing to the Speaker, and 3. If he is removed by a resolution passed by a majority of all the then members of the Assembly. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Speaker performs the duties of the Speaker's office when it is vacant. He also acts as the Speaker when the latter is absent from the sitting of Assembly. In both the cases, he has all the powers of the Speaker. The Speaker nominates from amongst the members a panel of chairmen. Any one of them can preside over the Assembly in the absence of the Speaker or the Deputy Speaker. He has the same powers as the Speaker when so presiding. He holds office until a new panel of chairmen is nominated. Chairman of Council. The chairman is elected by the council itself from amongst its members. The chairman vacates his office in any of the following three cases. 1. If he ceases to be a member of the council. 2. If he resigns by writing to the deputy chairman. And 3. If he is removed by a resolution passed by a majority of all the then members of the council. Such a resolution can be moved only after giving 14 days advance notice. As a presiding officer, the powers and functions of the chairman in the council are similar to those of the speaker in the assembly. However, the speaker has one special power which is not enjoyed by the chairman. The speaker decides whether a bill is a money bill or not, and his decision on this question is final. The salaries and allowances of the Speaker and the Deputy Speaker of the Assembly and the Chairman and the Deputy Chairman of the Council are fixed by the state legislature. They are charged on the consolidated fund of the state and thus are not subject to the annual vote of the state legislature. Deputy Chairman of Council. Like the Chairman, the Deputy Chairman is also elected by the Council itself from amongst its members. The Deputy Chairman vacates his office in any of the following three cases. 1. If he ceases to be a member of the Council. 2. If he resigns by writing to the Chairman. And 3. If he is removed by a resolution passed by a majority of all the then members of the Council. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Chairman performs the duties of the Chairman's office when it is vacant. He also acts as the Chairman when the latter is absent from the sitting of the Council. In both the cases, he has all the powers of the Chairman. The Chairman nominates from amongst the members a panel of Vice Chairmen. Any one of them can preside over the Council in the absence of the Chairman or the Deputy Chairman. He has the same powers as the chairman when so presiding. He holds office until a new panel of vice chairmen is nominated. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. M. Laxmikanth, Indian Polity. Chapter 33. State Legislature. Sessions of State Legislature. Summoning. The Governor from time to time summons each House of State Legislature to meet. The maximum gap between the two sessions of State Legislature cannot be more than 6 months, i.e., the State Legislature should meet at least twice a year. A session of the State Legislature consists of many sittings. Adjournment. An adjournment suspends the work in a sitting for a specified time, which may be hours, days or weeks. Adjournment sine die means terminating a sitting of the state legislature for an indefinite period. The power of the adjournment as well as adjournment sine die lies with the presiding officer of the House. Prorogation. The presiding officer, Speaker or Chairman, declares the House adjourned sine die when the business of the session is completed. Within the next few days, the Governor issues a notification for prorogation of the session. However, the Governor can also prorogue the House which is in session. Unlike an adjournment, a prorogation terminates a session of the House. Dissolution. The Legislative Council, being a permanent House, is not subject to dissolution. Only the Legislative Assembly is subject to dissolution. Unlike a prorogation, a dissolution ends the very life of the existing House, and a new House is constituted after the general elections are held. The position with respect to lapsing of bills on the dissolution of the Assembly is mentioned below. 1. A bill pending in the Assembly lapses, whether originating in the Assembly or transmitted to it by the Council. 2. A bill passed by the Assembly but pending in the Council lapses. 3. A bill pending in the Council but not passed by the Assembly does not lapse. 4. A bill passed by the Assembly in a unicameral state or passed by both the Houses in a bicameral state but pending assent of the Governor or the President does not lapse. 5. A bill passed by the Assembly in a unicameral state or passed by both the Houses in a bicameral state but returned by the President for reconsideration of House does not lapse. Quorum. Quorum is the minimum number of members required to be present in the House before it can transact any business. It is 10 members or 1/10 of the total number of members of the House, including the presiding officer, whichever is greater. If there is no quorum during a meeting of the House, it is the duty of the presiding officer either to adjourn the House or to suspend the meeting until there is a quorum. Voting in House. All matters at any sitting of either House are decided by a majority of votes of the members present and voting excluding the presiding officer. Only a few matters which are specifically mentioned in the Constitution, like removal of the Speaker of the Assembly, removal of the Chairman of the Council, and so on, require special majority, not ordinary majority. The presiding officer, i.e., Speaker in the case of Assembly or Chairman in the case of Council, or the person acting as such, does not vote in the first instance, but exercises a casting vote in the case of an equality of votes. Language in state legislature. The Constitution has declared the official languages of the state, or Hindi or English, to be the languages for transacting business in the state legislature. However, the presiding officer can permit a member to address the House in his mother tongue. The state legislature is authorized to decide whether to continue or discontinue English as a floor language after the completion of 15 years from the commencement of the Constitution, i.e., from 1965. In case of Himachal Pradesh, Manipur, Meghalaya and Tripura, this time limit is 25 years, and that of Arunachal Pradesh, Goa and Mizoram, it is 40 years. Rights of Ministers and Advocate General. In addition to the members of a House, every minister and the Advocate General of the state have the right to speak and take part in the proceedings of either House or any of its committees of which he is named a member, without being entitled to vote. There are two reasons underlying this constitutional provision. 1. A minister can participate in the proceedings of a House of which he is not a member. 2. A minister who is not a member of either House can participate in the proceedings of both the Houses. Legislative procedure in state legislature. Ordinary bills. Bill in the originating House. An ordinary bill can originate in either House of the state legislature in case of a bicameral legislature. Such a bill can be introduced either by a minister or by any other member. The bill passes through 3 stages in the originating House, viz. 1. First reading, 2. Second reading, and 3. Third reading. After the bill is passed by the originating House, it is transmitted to the second House for consideration and passage. A bill is deemed to have been passed by the state legislature only when both the Houses have agreed to it, either with or without amendments. In case of a unicameral legislature, a bill passed by the Legislative Assembly is sent directly to the Governor for his assent. Bill in the second House. in the second house also, the bill passes through all the three stages. That is, first reading, second reading and third reading. When a bill is passed by the Legislative Assembly and transmitted to the Legislative Council, the latter has four alternatives before it. 1. It may pass the bill as sent by the Assembly, i.e., without amendments. 2. It may pass the bill with amendments and return it to the Assembly for reconsideration. 3. It may reject the bill altogether. And 4. It may not take any action and thus keep the bill pending. If the Council passes the bill without amendments or the Assembly accepts the amendments suggested by the Council, the bill is deemed to have been passed by both the Houses and the same is sent to the Governor for his assent. On the other hand, if the Assembly rejects the amendments suggested by the Council or the Council rejects the bill altogether or the Council does not take any action for 3 months, then the Assembly may pass the bill again and transmit the same to the Council. If the Council rejects the bill again or passes the bill with amendments not acceptable to the Assembly or does not pass the bill within 1 month, then the bill is deemed to have been passed by both the Houses in the form in which it was passed by the Assembly for the second time. Therefore, the ultimate power of passing an ordinary bill is vested in the Assembly. At the most, the Council can detain or delay the bill for a period of 4 months, 3 months in the first instance and 1 month in the second instance. The Constitution does not provide for the mechanism of joint sitting of both the Houses to resolve the disagreement between the two Houses over a bill. On the other hand, there is a provision for joint sitting of the Lok Sabha and the Rajya Sabha to resolve a disagreement between the two over an ordinary bill. Moreover, when a bill, which has originated in the Council and was sent to the Assembly, is rejected by the Assembly, the bill ends and becomes dead. Thus, the Council has been given much lesser significance, position, and authority than that of the Rajya Sabha at the centre. Assent of the Governor. Every bill, after it is passed by the Assembly or by both the Houses in case of a bicameral legislature, is presented to the Governor for his assent. There are 4 alternatives before the Governor. 1. He may give his assent to the bill. 2. He may withhold his assent to the bill. 3. He may return the bill for reconsideration of the House or Houses. And 4. He may reserve the bill for the consideration of the President. If the Governor gives his assent to the bill becomes an act and is placed on the statute book. If the Governor withholds his assent to the bill ends and does not become an act. If the Governor returns the bill for reconsideration and if the bill is passed by the House or both the Houses again, with or without amendments, and presented to the Governor for his assent, the Governor must give his assent to the bill. Thus, the Governor enjoys only a suspensive veto. The position is same at the central level also. Assent of the President. When a bill is reserved by the Governor for the consideration of the President may either give his assent to the bill or withhold his assent to the bill or return the bill for reconsideration of the House or Houses of the state legislature. When a bill is so returned, the House or Houses have to reconsider it within a period of 6 months. The bill is presented again to the presidential assent after it is passed by the House or Houses with or without amendments. It is not mentioned in the Constitution whether it is obligatory on the part of the President to give his assent to such a bill or not. Money bills. The Constitution lays down a special procedure for the passing of money bills in the state legislature. This is as follows. A money bill cannot be introduced in the Legislative Council. It can be introduced in the Legislative Assembly only, and that too on the recommendation of the Governor. Every such bill is considered to be a government bill and can be introduced only by a minister. After a money bill is passed by the Legislative Assembly, it is transmitted to the Legislative Council for its consideration. The Legislative Council has restricted powers with regard to a money bill. It cannot reject or amend a money bill. It can only make recommendations and must return the bill to the Legislative Assembly within 14 days. The Legislative Assembly can either accept or reject all or any of the recommendations of the Legislative Council. If the Legislative Assembly accepts any recommendation, the bill is then deemed to have been passed by both the houses in the modified form. If the Legislative Assembly does not accept any recommendation, the bill is then deemed to have been passed by both the houses in the form originally passed by the Legislative Assembly without any change. If the Legislative Council does not return the bill to the Legislative Assembly within 14 days, the bill is deemed to have been passed by both houses at the expiry of the said period in the form originally passed by the Legislative Assembly. Thus, the Legislative Assembly has more powers than Legislative Council with regard to a money bill. At the most, the Legislative Council can detain or delay a money bill for a period of 14 days. Finally, when a money bill is presented to the governor, he may either give his assent, withhold his assent or reserve the bill for presidential assent but cannot return the bill for reconsideration of the state legislature. Normally, the governor gives his assent to a money bill as it is introduced in the state legislature with his prior permission. When a money bill is reserved for consideration of the president may either give his assent to the bill or withhold his assent to the bill but cannot return the bill for reconsideration of the state legislature. Position of Legislative Council. The constitutional position of the Council, as compared with the Assembly, can be studied from two angles. A. Phase where Council is equal to Assembly. B. Phase where Council is unequal to Assembly. Equal with Assembly. In the following matters, the powers and status of the Council are broadly equal to that of the Assembly. 1. Introduction and passage of ordinary bills. However, in case of disagreement between the two houses, the will of the Assembly prevails over that of the Council. 2. Approval of ordinances issued by the Governor. 3. Selection of ministers including the Chief Minister. Under the Constitution, the ministers including the Chief Minister can be members of either house of the state legislature. However, irrespective of their membership, they are responsible only to the Assembly. 4. Consideration of the reports of the constitutional bodies like State Finance Commission, State Public Service Commission and Controller and Auditor General of India. 5. Enlargement of the jurisdiction of the State Public Service Commission. Unequal with Assembly. In the following matters, the powers and status of the Council are unequal to that of the Assembly. 1. A money bill can be introduced only in the Assembly and not in the Council. 2. The Council cannot amend or reject a money bill. It should return the bill to the Assembly within 14 days, either with recommendations or without recommendations. 3. The Assembly can either accept or reject all or any of the recommendation of the Council. In both the cases, the money bill is deemed to have been passed by the two houses. 4. The final power to decide whether a particular bill is a money bill or not is vested in the Speaker of the Assembly. 5. The final power of passing an ordinary bill also lies with the Assembly. At the most, the Council can detain or delay the bill for the period of 4 months, 3 months in the first instance and 1 month in the second instance. In other words, the Council is not even a revising body like the Rajya Sabha, it is only a dilatory chamber or an advisory body. 6. The Council can only discuss the budget but cannot vote on the demands for grants, which is the exclusive privilege of the Assembly. 7. The Council cannot remove the Council of Ministers by passing a no-confidence motion. This is because the Council of Ministers is collectively responsible only to the Assembly. But the Council can discuss and criticize the policies and activities of the government. 8. When an ordinary bill, which has originated in the Council and was sent to the Assembly, is rejected by the Assembly, the bill ends and becomes dead. 9. The Council does not participate in the election of the President of India and representatives of the state in the Rajya Sabha. 10. The Council has no effective say in the ratification of a constitutional amendment bill. In this respect also, the will of the Assembly prevails over that of the Council. 11. Finally, the very existence of the Council depends on the will of the Assembly. The Council can be abolished by the Parliament on the recommendation of the Assembly. From the above, it is clear that the position of the Council vis-à-vis the Assembly is much weaker than the position of the Rajya Sabha vis-à-vis the Lok Sabha. The Rajya Sabha has equal powers with the Lok Sabha in all spheres except financial matters and with regard to the control over the government. On the other hand, the Council is subordinate to the Assembly in all respects. Thus, the predominance of the Assembly over the Council is fully established. Even though both the Council and the Rajya Sabha are second chambers, the Constitution has given the Council much lesser importance than the Rajya Sabha due to the following reasons. 1. The Rajya Sabha consists of the representatives of the states and thus reflect the federal element of the polity. It maintains the federal equilibrium by protecting the interests of the states against the undue interference of the center. Therefore, it has to be an effective revising body and not just an advisory body or dilatory body like that of the Council. On the other hand, the issue of federal significance does not arise in the case of a Council. 2. The Council is heterogeneously constituted. It represents different interests and consists of differently elected members, and also includes some nominated members. Its very composition makes its position weak and reduces its utility as an effective revising body. On the other hand, the Rajya Sabha is homogeneously constituted. It represents only the states and consists of mainly elected members. Only 12 out of 250 are nominated. 3. The position accorded to the Council is in accordance with the principles of democracy. The Council should yield to the Assembly, which is a popular house. This pattern of relationship between the two houses of the state legislature is adopted from the British model. In Britain, the House of Lords, upper house, cannot oppose and obstruct the House of Commons, lower house. The House of Lords is only a dilatory chamber. It can delay an ordinary bill for a maximum period of 1 year and a money bill for 1 month. Keeping in view its weak, powerless and insignificant position and role, the critics have described the Council as a secondary chamber, costly ornamental luxury, white elephant, etc. The critics have opined that the Council has served as a refuge for those who are defeated in the Assembly elections. It enabled the unpopular, rejected, and ambitious politicians to occupy the post of a chief minister or a member of the state legislature. Even though the Council has been given less powers as compared with the Assembly, its utility is supported on the following grounds. 1. It checks the hasty, defective, careless and ill-considered legislation made by the Assembly by making provision for revision and thought. 2. It facilitates representation of eminent professionals and experts who cannot face direct elections. The governor nominates 1/6 members of the council to provide representation to such people. Privileges of state legislature. Privileges of a state legislature are a sum of special rights, immunities, and exemptions enjoyed by the houses of state legislature, their committees and their members. They are necessary in order to secure the independence and effectiveness of their actions. Without these privileges, the houses can neither maintain their authority, dignity and honor nor can protect their members from any obstruction in the discharge of their legislative responsibilities. The Constitution has also extended the privileges of the state legislature to those persons who are entitled to speak and take part in the proceedings of a house of the state legislature or any of its committees. These include Advocate General of the state and state ministers. It must be clarified here that the privileges of the state legislature do not extend to the governor, who is also an integral part of the state legislature. The privileges of a state legislature can be classified into two broad categories: those that are enjoyed by each house of the state legislature collectively, and those that are enjoyed by the members individually. Collective privileges. The privileges belonging to each house of the state legislature collectively are: 1. It has the right to publish its reports, debates and proceedings, and also the right to prohibit others from publishing the same. 17. 2. It can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. 3. It can make rules to regulate its own procedure and the conduct of its business and to adjudicate upon such matters. 4. It can punish members as well as outsiders for breach of its privileges or its contempt by reprimand, admonition or imprisonment, also suspension or expulsion in case of members. 5. It has the right to receive immediate information of the arrest, detention, conviction, imprisonment and release of a member. 6. It can institute inquiries and order the attendance of witnesses and send for relevant papers and records. 7. The courts are prohibited to inquire into the proceedings of a house or its committees. 8. No person, either a member or outsider, can be arrested, and no legal process, civil or criminal, can be served within the precincts of the house without the permission of the presiding officer. Individual privileges. The privileges belonging to the members individually are: 1. They cannot be arrested during the session of the state legislature and 40 days before the beginning and 40 days after the end of such session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. 2. They have freedom of speech in the state legislature. No member is liable to any proceedings in any court for anything said or any vote given by him in the state legislature or its committees. This freedom is subject to the provisions of the Constitution and to the rules and standing orders regulating the procedure of the state legislature. 3. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when the state legislature is in session. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. Laxmikanth, Indian Polity. Chapter 34. High Court. In the Indian single integrated judicial system, the High Court operates below the Supreme Court but above the subordinate courts. The judiciary in a state consists of a High Court and a hierarchy of subordinate courts. The High Court occupies the top position in the judicial administration of a state. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay and Madras. In 1866, a fourth High Court was established at Allahabad. In the course of time, each province in British India came to have its own High Court. After 1950, a High Court existing in a province became the High Court for the corresponding state. The Constitution of India provides for a High Court for each state, but the 7th Amendment Act of 1956 authorized the Parliament to establish a common High Court for 2 or more states or for 2 or more states and a union territory. The territorial jurisdiction of a High Court is coterminous with the territory of a state. Similarly, the territorial jurisdiction of a common High Court is coterminous with the territories of the concerned states and union territory. At present, 2019, there are 25 High Courts in the country. Out of them, only 3 High Courts have jurisdiction over more than one state. Among the 9 union territories, Delhi alone has a separate High Court since 1966. The union territories of Jammu and Kashmir and Ladakh have a common High Court. The other union territories fall under the jurisdiction of different state High Courts. The Parliament can extend the jurisdiction of a High Court to any union territory or exclude the jurisdiction of a High Court from any union territory. Articles 214 to 231 in Part 6 of the Constitution deal with the organization, independence, jurisdiction, powers, procedures and so on of the High Courts, composition and appointment. Every High Court, whether exclusive or common, consists of a Chief Justice and such other judges as the President may from time to time deem necessary to appoint. Thus, the Constitution does not specify the strength of a High Court and leaves it to the discretion of the President. Accordingly, the President determines the strength of a High Court from time to time depending upon its workload. Appointment of judges. The judges of a High Court are appointed by the President. The Chief Justice is appointed by the President after consultation with the Chief Justice of India and the Governor of the state concerned. For appointment of other judges, the Chief Justice of the concerned High Court is also consulted. In case of a common High Court for 2 or more states, the governors of all the states concerned are consulted by the President. In the second judge's case, 1993, the Supreme Court ruled that no appointment of a judge of the High Court can be made unless it is in conformity with the opinion of the Chief Justice of India. In the third judge's case, 1998, the Supreme Court opined that in case of the appointment of High Court judges, the Chief Justice of India should consult a collegium of 2 senior-most judges of the Supreme Court. Thus, the sole opinion of the Chief Justice of India alone does not constitute the consultation process. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointments Commission Act of 2014 have replaced the collegium system of appointing judges to the Supreme Court and High Courts with a new body called the National Judicial Appointments Commission (NJC). However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as the NJC Act as unconstitutional and void. Consequently, the earlier collegium system became operative again. This verdict was delivered by the Supreme Court in the fourth judge's case 2015. The court opined that the new system, i.e., NJC, would affect the independence of the judiciary. Qualifications, oath and salaries. Qualifications of judges. A person to be appointed as a judge of a high court should have the following qualifications. 1. He should be a citizen of India. 2a. He should have held a judicial office in the territory of India for 10 years, or b. He should have been an advocate of a high court or high courts in succession for 10 years. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of a high court. Moreover, unlike in the case of the Supreme Court, the Constitution makes no provision for appointment of a distinguished jurist as a judge of a high court. Oath or affirmation. A person appointed as a judge of a high court, before entering upon his office, has to make and subscribe an oath or affirmation before the governor of the state or some person appointed by him for this purpose. In his oath, a judge of a high court swears 1. To bear true faith and allegiance to the Constitution of India. 2. To uphold the sovereignty and integrity of India. 3. To duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will, and 4. To uphold the Constitution and the laws. Salaries and allowances. The salaries, allowances, privileges, leave and pension of the judges of a high court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. In 2018, the salary of the Chief Justice was increased from 90,000 rupee to 2.50 lakh per month and that of a judge from 80,000 rupee to 2.25 lakh per month. They are also paid sumptuary allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. The retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. Tenure, removal and transfer. Tenure of judges. The Constitution has not fixed the tenure of a judge of a high court. However, it makes the following 4 provisions in this regard. 1. He holds office until he attains the age of 62 years. Any questions regarding his age is to be decided by the President after consultation with the Chief Justice of India and the decision of the President is final. 2. He can resign his office by writing to the President. 3. He can be removed from his office by the President on the recommendation of the Parliament. 4. He vacates his office when he is appointed as a judge of the Supreme Court or when he is transferred to another high court. Removal of judges. A judge of a high court can be removed from his office by an order of the President. The President can issue the removal order only after an address by the Parliament has been presented to him in the same session for such removal. The address must be supported by a special majority of each House of Parliament, i.e., a majority of the total membership of that House and majority of not less than 2/3 of the members of that House present and voting. The grounds of removal are 2. Proved misbehavior or incapacity. Thus, a judge of a high court can be removed in the same manner and on the same grounds as a judge of the Supreme Court. The Judges' Enquiry Act, 1968, regulates the procedure relating to the removal of a judge of a high court by the process of impeachment. 1. A removal motion signed by 100 members, in the case of Lok Sabha, or 50 members, in the case of Rajya Sabha, is to be given to the Speaker Chairman. 2. The Speaker Chairman may admit the motion or refuse to admit it. 3. If it is admitted, then the Speaker Chairman is to constitute a 3-member committee to investigate into the charges. 4. The committee should consist of a. The Chief Justice or a judge of the Supreme Court, b. A Chief Justice of a High Court, and c. A distinguished jurist. 5. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. 6. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. 7. Finally, the President passes an order removing the judge. From the above, it is clear that the procedure for the impeachment of a judge of a high court is the same as that for a judge of the Supreme Court. It is interesting to know that no judge of a high court has been impeached so far. Transfer of judges. The President can transfer a judge from one high court to another after consulting the Chief Justice of India. On transfer, he is entitled to receive in addition to his salary such compensatory allowance as may be determined by Parliament. In 1977, the Supreme Court ruled that the transfer of High Court judges could be resorted to only as an exceptional measure and only in public interest and not by way of punishment. Again in 1994, the Supreme Court held that judicial review is necessary to check arbitrariness in transfer of judges. But only the judge who is transferred can challenge it. In the third judge's case, 1998, the Supreme Court opined that in case of the transfer of High Court judges, the Chief Justice of India should consult, in addition to the collegium of 4 senior-most judges of the Supreme Court, the Chief Justice of the 2 High Courts, one from which the judge is being transferred and the other receiving him. Thus, the sole opinion of the Chief Justice of India does not constitute the consultation process. Acting, additional and retired judges. Acting Chief Justice. The President can appoint a judge of a High Court as an acting Chief Justice of the High Court when 1. The office of Chief Justice of the High Court is vacant or 2. The Chief Justice of the High Court is temporarily absent or 3. The Chief Justice of the High Court is unable to perform the duties of his office. Additional and acting judges. The President can appoint duly qualified persons as additional judges of a high court for a temporary period not exceeding 2 years when 1. There is a temporary increase in the business of the High Court or 2. There are arrears of work in the High Court. The President can also appoint a duly qualified person as an acting judge of a high court when a judge of that high court, other than the Chief Justice, is 1. Unable to perform the duties of his office due to absence or any other reason or 2. Appointed to act temporarily as Chief Justice of that high court. An acting judge holds office until the permanent judge resumes his office. However, both the additional or acting judge cannot hold office after attaining the age of 62 years. Retired judges. At any time, the Chief Justice of a High Court of a state can request a retired judge of that High Court or any other High Court to act as a judge of the High Court of that state for a temporary period. He can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. He will also enjoy all the jurisdiction, powers and privileges of a judge of that high court. But he will not otherwise be deemed to be a judge of that high court. Independence of High Court. The independence of a high court is very essential for the effective discharge of the duties assigned to it. It should be free from the encroachments, pressures and interferences of the executive, council of ministers, and the legislature. It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of a high court. 1. Mode of appointment. The judges of a high court are appointed by the President, which means the Cabinet, in consultation with the members of the judiciary itself, i.e., Chief Justice of India and the Chief Justice of the High Court. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical considerations. 2. Security of tenure. The judges of a high court are provided with the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President, though they are appointed by him. This is obvious from the fact that no judge of a high court has been removed or impeached so far. 3. Fixed service conditions. The salaries, allowances, privileges, leave and pension of the judges of a high court are determined from time to time by the Parliament. But they cannot be changed to their disadvantage after their appointment except during a financial emergency. Thus, the conditions of service of the judges of a high court remain same during their term of office. 4. Expenses charged on consolidated fund. The salaries and allowances of the judges, the salaries, allowances and pensions of the staff as well as the administrative expenses of a high court are charged on the consolidated fund of the state. Thus, they are non-votable by the state legislature, though they can be discussed by it. It should be noted here that the pension of a High Court judge is charged on the Consolidated Fund of India and not the state. 5. Conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in a state legislature with respect to the conduct of the judges of a High Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. 6. Ban on practice after retirement. The retired permanent judges of a high court are prohibited from pleading or acting in any court or before any authority in India except the Supreme Court and the other high courts. This ensures that they do not favor anyone in the hope of future favor. 7. Power to punish for its contempt. A high court can punish any person for its contempt. Thus, its actions and decisions cannot be criticized and opposed by anybody. This power is vested in a high court to maintain its authority, dignity and honor. 8. Freedom to appoint its staff. The Chief Justice of a high court can appoint officers and servants of the high court without any interference from the executive. He can also prescribe their conditions of service. 9. Its jurisdiction cannot be curtailed. The jurisdiction and powers of a high court insofar as they are specified in the Constitution cannot be curtailed both by the Parliament and the state legislature. But, in other respects, the jurisdiction and powers of a high court can be changed both by the Parliament and the state legislature. 10. Separation from executive. The Constitution directs the state to take steps to separate the judiciary from the executive in public services. This means that the executive authorities should not possess the judicial powers. Consequent upon its implementation, the role of executive authorities in judicial administration came to an end. Jurisdiction and powers of High Court. Like the Supreme Court, the High Court has been vested with quite extensive and effective powers. It is the highest court of appeal in the state. It is the protector of the fundamental rights of the citizens. It is vested with the power to interpret the Constitution. Besides, it has supervisory and consultative roles. However, the Constitution does not contain detailed provisions with regard to the jurisdiction and powers of a high court. It only lays down that the jurisdiction and powers of a high court are to be the same as immediately before the commencement of the Constitution. But there is one addition, that is, the Constitution gives a high court jurisdiction over revenue matters, which it did not enjoy in the pre-Constitution era. The Constitution also confers, by other provisions, some more additional powers on a high court like writ jurisdiction, power of superintendence, consultative power, etc. Moreover, it empowers the Parliament and the state legislature to change the jurisdiction and powers of a high court. At present, a high court enjoys the following jurisdiction and powers. 1. Original jurisdiction. 2. Writ jurisdiction. 3. Appellate jurisdiction. 4. Supervisory jurisdiction. 5. Control over subordinate courts. 6. A court of record. 7. Power of judicial review. The present jurisdiction and powers of a High Court are governed by a. The constitutional provisions, b. The letters patent, c. The Acts of Parliament, d. The Acts of State Legislature, e. Indian Penal Code, 1860, f. Criminal Procedure Code, 1973, and g. Civil Procedure Code, 1908. 1. Original jurisdiction. It means the power of a High Court to hear disputes in the first instance, not by way of appeal. It extends to the following: a. Matters of admiralty and contempt of court. b. Disputes relating to the election of members of parliament and state legislatures. c. Regarding revenue matter or an act ordered or done in revenue collection. d. Enforcement of fundamental rights of citizens. e. Cases ordered to be transferred from a subordinate court involving the interpretation of the Constitution to its own file. f. The 4 High Courts, i.e., Calcutta, Bombay, Madras and Delhi High Courts, have original civil jurisdiction in cases of higher value. Before 1973, the Calcutta, Bombay and Madras High Courts also had original criminal jurisdiction. This was fully abolished by the Criminal Procedure Code, 1973. 2. Writ jurisdiction. Article 226 of the Constitution empowers a High Court to issue writs including habeas corpus, mandamus, certiorari, prohibition and quo warranto for the enforcement of the fundamental rights of the citizens and for any other purpose. The phrase "for any other purpose" refers to the enforcement of an ordinary legal right. The High Court can issue writs to any person, authority and government not only within its territorial jurisdiction but also outside its territorial jurisdiction if the cause of action arises within its territorial jurisdiction. The writ jurisdiction of the High Court, under Article 226, is not exclusive but concurrent with the writ jurisdiction of the Supreme Court, under Article 32. It means, when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. However, the writ jurisdiction of the High Court is wider than that of the Supreme Court. This is because the Supreme Court can issue writs only for the enforcement of fundamental rights and not for any other purpose, that is, it does not extend to a case where the breach of an ordinary legal right is alleged. In the Chandra Kumar case, 1997, the Supreme Court ruled that the writ jurisdiction of both the High Court and the Supreme Court constitute a part of the basic structure of the Constitution. Hence, it cannot be ousted or excluded even by way of an amendment to the Constitution. 3. Appellate jurisdiction. A High Court is primarily a court of appeal. It hears appeals against the judgments of subordinate courts functioning in its territorial jurisdiction. It has appellate jurisdiction in both civil and criminal matters. Hence, the appellate jurisdiction of a High Court is wider than its original jurisdiction. A. Civil matters. The civil appellate jurisdiction of a High Court is as follows. 1. First, appeals from the orders and judgments of the district courts, additional district courts and other subordinate courts lie directly to the High Court on both questions of law and fact if the amount exceeds the stipulated limit. 2. Second, appeals from the orders and judgments of the district court or other subordinate courts lie to the High Court in the cases involving questions of law only, and not questions of fact. 3. The Calcutta, Bombay and Madras High Courts have provision for intra-court appeals. When a single judge of the High Court has decided a case, either under the original or appellate jurisdiction of the High Court, an appeal from such a decision lies to the division bench of the same High Court. 4. Appeals from the decisions of the administrative, and other tribunals lie to the division bench of the State High Court. In 1997, the Supreme Court ruled that the tribunals are subject to the writ jurisdiction of the High Courts. Consequently, it is not possible for an aggrieved person to approach the Supreme Court directly against the decisions of the tribunals without first going to the High Courts. B. Criminal matters. The criminal appellate jurisdiction of a High Court is as follows. 1. Appeals from the judgments of Sessions Court and Additional Sessions Court lie to the High Court if the sentence is one of imprisonment for more than 7 years. It should also be noted here that a death sentence, popularly known as capital punishment, awarded by a Sessions Court or an Additional Sessions Court should be confirmed by the High Court before it can be executed, whether there is an appeal by the convicted person or not. 2. In some cases specified in various provisions of the Criminal Procedure Code, 1973, the appeals from the judgments of the Assistant Sessions Judge, Metropolitan Magistrate or other magistrates, judicial, lie to the High Court. 4. Supervisory jurisdiction. A High Court has the power of superintendence over all courts and tribunals functioning in its territorial jurisdiction, except military courts or tribunals. Thus, it may a. call for returns from them, b. make and issue general rules and prescribe forms for regulating the practice and proceedings of them, c. prescribe forms in which books, entries and accounts are to be kept by them, and d. settle the fees payable to the sheriff, clerks, officers and legal practitioners of them. This power of superintendence of a High Court is very broad because 1. It extends to all courts and tribunals whether they are subject to the appellate jurisdiction of the High Court or not. 2. It covers not only administrative superintendence but also judicial superintendence. 3. It is a revisional jurisdiction. And 4. It can be suo motu on its own and not necessarily on the application of a party. However, this power does not vest the High Court with any unlimited authority over the subordinate courts and tribunals. It is an extraordinary power and hence has to be used most sparingly and only in appropriate cases. Usually, it is limited to 1. Excess of jurisdiction, 2. Gross violation of natural justice, 3. Error of law, 4. Disregard to the law of superior courts, 5. Perverse findings, and 6. Manifest injustice. 5. Control over subordinate courts. In addition to its appellate jurisdiction and supervisory jurisdiction over the subordinate courts as mentioned above, a High Court has an administrative control and other powers over them. These include the following. A. It is consulted by the governor in the matters of appointment, posting and promotion of district judges and in the appointments of persons to the judicial service of the state, other than district judges. B. It deals with the matters of posting, promotion, grant of leave, transfers and discipline of the members of the judicial service of the state, other than district judges. C. It can withdraw a case pending in a subordinate court if it involves a substantial question of law that require the interpretation of the Constitution. It can then either dispose of the case itself or determine the question of law and return the case to the subordinate court with its judgment. D. Its law is binding on all subordinate courts functioning within its territorial jurisdiction in the same sense as the law declared by the Supreme Court is binding on all courts in India. 6. A court of record. As a court of record, a High Court has two powers. A. The judgments, proceedings and acts of the High Courts are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedents and legal references. B. It has power to punish for contempt of court, either with simple imprisonment or with fine or with both. The expression contempt of court has not been defined by the Constitution. However, the expression has been defined by the Contempt of Court Act of 1971. Under this, contempt of court may be civil or criminal. Civil contempt means willful disobedience to any judgment, order, writ or other process of a court or willful breach of an undertaking given to a court. Criminal contempt means the publication of any matter or doing an act which 1. Scandalizes or lowers the authority of a court, or 2. Prejudices or interferes with the due course of a judicial proceeding, or 3. Interferes or obstructs the administration of justice in any other manner. However, innocent publication and distribution of some matter, fair and accurate report of judicial proceedings, fair and reasonable criticism of judicial acts and comment on the administrative side of the judiciary do not amount to contempt of court. As a court of record, a high court also has the power to review and correct its own judgment or order or decision, even though no specific power of review is conferred on it by the Constitution. The Supreme Court, on the other hand, has been specifically conferred with the power of review by the Constitution. 7. Power of judicial review. Judicial review is the power of a high court to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional and invalid, null and void, by the High Court. Consequently, they cannot be enforced by the government. Though the phrase judicial review has nowhere been used in the Constitution, the provisions of Articles 13 and 226 explicitly confer the power of judicial review on a high court. The constitutional validity of a legislative enactment or an executive order can be challenged in a high court on the following 3 grounds. A. It infringes the fundamental rights, Part 3. B. It is outside the competence of the authority which has framed it, and C. It is repugnant to the constitutional provisions. The 42nd Amendment Act of 1976 curtailed the judicial review power of High Court. It debarred the High Courts from considering the constitutional validity of any central law. However, the 43rd Amendment Act of 1977 restored the original position. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. M. Laxmikanth, Indian Polity. Chapter 35. Tribunals. The original Constitution did not contain provisions with respect to tribunals. The 42nd Amendment Act of 1976 added a new Part 14A to the Constitution. This part is entitled as Tribunals and consists of only 2 articles, Article 323A dealing with administrative tribunals and Article 323B dealing with tribunals for other matters. Administrative Tribunals. Article 323A empowers the Parliament to provide for the establishment of administrative tribunals for the adjudication of disputes relating to recruitment and conditions of service of persons appointed to public services of the centre, the states, local bodies, public corporations, and other public authorities. In other words, Article 323A enables the Parliament to take out the adjudication of disputes relating to service matters from the civil courts and the high courts and place it before the administrative tribunals. In pursuance of Article 323A, the Parliament has passed the Administrative Tribunals Act in 1985. The Act authorizes the central government to establish one central administrative tribunal and the state administrative tribunals. This act opened a new chapter in the sphere of providing speedy and inexpensive justice to the aggrieved public servants. Central Administrative Tribunal, CAT. The Central Administrative Tribunal, CAT, was set up in 1985 with the principal bench at Delhi and additional benches in different states. At present, it has 17 regular benches, 15 of which operate at the principal seats of high courts and the remaining two at Jaipur and Lucknow. These benches also hold circuit sittings at other seats of high courts. The CAT exercises original jurisdiction in relation to recruitment and all service matters of public servants covered by it. Its jurisdiction extends to the All India Services, the Central Civil Services, civil posts under the centre and civilian employees of defence services. However, the members of the defence forces, officers and servants of the Supreme Court and the secretarial staff of the Parliament are not covered by it. The CAT is a multi-member body consisting of a chairman and members. Originally, the CAT consisted of a chairman, vice-chairman and members. Later, in 2006, the provision for the vice-chairman was removed by the Administrative Tribunals Amendment Act 2006. Hence, there are now no vice-chairman in the CAT. At present, 2019, the sanctioned strength of the chairman is 1 and sanctioned strength of the members is 65. They are drawn from both judicial and administrative streams and are appointed by the President. They hold office for a term of 5 years or until they attain the age of 65 years in case of chairman and 62 years in case of members, whichever is earlier. The appointment of members in CAT is made on the basis of recommendations of a high-powered selection committee chaired by a sitting judge of Supreme Court who is nominated by the Chief Justice of India. After obtaining the concurrence of Chief Justice of India, appointments are made with the approval of Appointments Committee of the Cabinet, ACC. The CAT is not bound by the procedure laid down in the Civil Procedure Code of 1908. It is guided by the principles of natural justice. These principles keep the CAT flexible in approach. Only a nominal fee of 50 rupees is to be paid by the applicant. The applicant may appear either in person or through a lawyer. Originally, appeals against the orders of the CAT could be made only in the Supreme Court and not in the High Courts. However, in the Chandra Kumar case 2, 1997, the Supreme Court declared this restriction on the jurisdiction of the High Courts as unconstitutional, holding that judicial review is a part of the basic structure of the Constitution. It laid down that appeals against the orders of the CAT shall lie before the division bench of the concerned High Court. Consequently, now it is not possible for an aggrieved public servant to approach the Supreme Court directly against an order of the CAT without first going to the concerned High Court. State Administrative Tribunals. The Administrative Tribunals Act of 1985 empowers the central government to establish the state administrative tribunals, SATs, on specific request of the concerned state governments. So far, 2019, the SATs have been set up in the 9 states of Andhra Pradesh, Himachal Pradesh, Odisha, Karnataka, Madhya Pradesh, Maharashtra, Tamil Nadu, West Bengal and Kerala. However, the Madhya Pradesh, Tamil Nadu and Himachal Pradesh tribunals have since been abolished. But subsequently, the Himachal Pradesh re-established the SAT and the state of Tamil Nadu has also requested now to re-establish the same. Further, the state government of Haryana has requested to establish the SAT for their state. On the other hand, the state government of Odisha has submitted a proposal for abolition of Odisha Administrative Tribunal. Like the CAT, the SATs exercise original jurisdiction in relation to recruitment and all service matters of state government employees. The chairman and members of the SATs are appointed by the President after consultation with the governor of the state concerned. The Act also makes a provision for setting up of joint administrative tribunal (JAT) for two or more states. A JAT exercises all the jurisdiction and powers exercisable by the administrative tribunals for such states. The chairman and members of a JAT are appointed by the President after consultation with the governors of the concerned states. Tribunals for other matters. Under Article 323b, the Parliament and the state legislatures are authorized to provide for the establishment of tribunals for the adjudication of disputes relating to the following matters: a. Taxation. b. Foreign exchange, import and export. c. Industrial and labor. d. Land reforms. e. Sealing on urban property. f. Elections to Parliament and state legislatures. g. Foodstuffs. h. Rent and tenancy rights. Articles 323a and 323b differs in the following three aspects. 1. While Article 323a contemplates establishment of tribunals for public service matters only, Article 323b contemplates establishment of tribunals for certain other matters mentioned above. 2. While tribunals under Article 323a can be established only by Parliament, tribunals under Article 323b can be established both by Parliament and state legislatures with respect to matters falling within their legislative competence. 3. Under Article 323a, only one tribunal for the centre and one for each state or two or more states may be established. There is no question of hierarchy of tribunals, whereas under Article 323b a hierarchy of tribunals may be created. In Chandra Kumar case, 1997, the Supreme Court declared those provisions of these two articles which excluded the jurisdiction of the High Courts and the Supreme Court as unconstitutional. Hence, the judicial remedies are now available against the orders of these tribunals. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. M. Laxmikanth, Indian Polity. Chapter 36. Subordinate Courts. The state judiciary consists of a high court and a hierarchy of subordinate courts, also known as lower courts. The subordinate courts are so called because of their subordination to the state high court. They function below and under the high court at district and lower levels. Constitutional provisions. Articles 233 to 237 in Part 6 of the Constitution make the following provisions to regulate the organization of subordinate courts and to ensure their independence from the executive. 1. Appointment of district judges. The appointment, posting and promotion of district judges in a state are made by the governor of the state in consultation with the High Court. A person to be appointed as district judge should have the following qualifications. A. He should not already be in the service of the central or the state government. B. He should have been an advocate or a pleader for 7 years. C. He should be recommended by the High Court for appointment. 2. Appointment of district judges. Appointment of persons, other than district judges, to the judicial service of a state are made by the governor of the state after consultation with the State Public Service Commission and the High Court. 3. Control over subordinate courts. The control over district courts and other subordinate courts, including the posting, promotion and leave of persons belonging to the judicial service of a state and holding any post inferior to the post of district judge, is vested in the High Court. 4. Interpretation. The expression district judge includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, Chief Judge of a Small Cause Court, Chief Presidency Magistrate, Additional Chief Presidency Magistrate, Sessions Judge, Additional Sessions Judge and Assistant Sessions Judge. The expression judicial service means a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. 5. Application of the above provisions. To certain magistrates, the governor may direct that the above-mentioned provisions relating to persons in the state judicial service would apply to any class or classes of magistrates in the state. Structure and jurisdiction. The organizational structure, jurisdiction, and nomenclature of the subordinate judiciary are laid down by the states. Hence, they differ slightly from state to state. Broadly speaking, there are 3 tiers of civil and criminal courts below the High Court. This is shown as follows. The district judge is the highest judicial authority in the district. He possesses original and appellate jurisdiction in both civil as well as criminal matters. In other words, the district judge is also the sessions judge. When he deals with civil cases, he is known as the district judge, and when he hears the criminal cases, he is called as the sessions judge. The district judge exercises both judicial and administrative powers. He also has supervisory powers over all the subordinate courts in the district. Appeals against his orders and judgments lie to the High Court. The sessions judge has the power to impose any sentence including life imprisonment and capital punishment, death sentence. However, a capital punishment passed by him is subject to confirmation by the High Court whether there is an appeal or not. Below the district and sessions court stands the Court of Subordinate Judge on the civil side and the Court of Chief Judicial Magistrate on the criminal side. The subordinate judge exercises unlimited pecuniary jurisdiction over civil suits. The Chief Judicial Magistrate decides criminal cases which are punishable with imprisonment for a term up to 7 years. At the lowest level, on the civil side, is the Court of Munsif, and on the criminal side is the Court of Judicial Magistrate. The Munsif possesses limited jurisdiction and decides civil cases of small pecuniary stake. The Judicial Magistrate tries criminal cases which are punishable with imprisonment for a term up to 3 years. In some metropolitan cities, there are city civil courts, chief judges on the civil side and the courts of metropolitan magistrates on the criminal side. Some of the states and presidency towns have established small causes courts. These courts decide the civil cases of small value in a summary manner. Their decisions are final, but the High Court possesses a power of revision. In some states, panchayat courts try petty civil and criminal cases. They are variously known as Nyaya Panchayat, Gram Kucheri, Adalti Panchayat, Panchayat Adalat and so on. National Legal Services Authority. Article 39 of the Constitution of India provides for free legal aid to the poor and weaker sections of the society and ensures justice for all. Articles 14 and 22(1) of the Constitution also make it obligatory for the state to ensure equality before law and a legal system which promotes justice on the basis of equal opportunity to all. In the year 1987, the Legal Services Authorities Act was enacted by the Parliament, which came into force on 9 November 1995 to establish a nationwide uniform network for providing free and competent legal services to the weaker sections of the society on the basis of equal opportunity. The National Legal Services Authority, NALSA, has been constituted under the Legal Services Authorities Act 1987 to monitor and evaluate implementation of legal aid programs and to lay down policies and principles for making legal services available under the Act. In every state, a state legal services authority, and in every high court, a high court legal services committee have been constituted. The district legal services authorities, taluk legal services committees have been constituted in the districts and most of the taluks to give effect to the policies and directions of the Nalsa and to provide free legal services to the people and conduct lok adalats in the state. The Supreme Court Legal Services Committee has been constituted to administer and implement the legal services program insofar as it relates to the Supreme Court of India. The Nalsa lays down policies, principles, guidelines and frames effective and economical schemes for the state legal services authorities to implement the legal services programs throughout the country. Primarily, the state legal services authorities, district legal services authorities, taluk legal services committees, etc. have been asked to discharge the following main functions on regular basis. 1. To provide free and competent legal services to the eligible persons. 2. To organize lok adalats for amicable settlement of disputes. 3. To organize legal awareness camps in the rural areas. The free legal services include a. Payment of court fee, process fees and all other charges payable or incurred in connection with any legal proceedings. B. Providing service of lawyers in legal proceedings. C. Obtaining and supply of certified copies of orders and other documents in legal proceedings. D. Preparation of appeal, paper book including printing and translation of documents in legal proceedings. The persons eligible for getting free legal services include 1. Women and children. 2. Members of SC Cent. 3. Industrial workmen. 4. Victims of mass disaster, violence, flood, drought, earthquake, industrial disaster. 5. Disabled persons. 6. Persons in custody. 7. Persons whose annual income does not exceed 1 lakh rupees. In the Supreme Court Legal Services Committee the limit is 8. Victims of trafficking in human beings or begar. Lok Adalats. The Lok Adalat is a forum where the cases or disputes which are pending in a court or which are at pre-litigation stage, not yet brought before a court, are compromised or settled in an amicable manner. Meaning. The Supreme Court has explained the meaning of the institution of Lok Adalat in the following way. The Lok Adalat is an old form of adjudicating system prevailed in ancient India and its validity has not been taken away even in the modern days too. The word Lok Adalat means people's court. This system is based on Gandhian principles. It is one of the components of ADR, Alternative Dispute Resolution System. As the Indian courts are overburdened with the backlog of cases and the regular courts are to decide the cases involving a lengthy, expensive and tedious procedure. The court takes years together to settle even petty cases. The Lok Adalat, therefore, provides alternative resolution or device for expeditious and inexpensive justice. In Lok Adalat proceedings, there are no victors and vanquished and thus no rancor. The experiment of Lok Adalat as an alternate mode of dispute settlement has come to be accepted in India as a viable, economic, efficient and informal one. The Lok Adalat is another alternative in judicial justice. This is a recent strategy for delivering informal, cheap and expeditious justice to the common man by way of settling disputes which are pending in courts and also those which have not yet reached courts by negotiation, conciliation and by adopting persuasive, common sense and human approach to the problems of the disputants with the assistance of specially trained and experienced members of a team of conciliators. Statutory status. The first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. This initiative proved very successful in the settlement of disputes. Consequently, the institution of Lok Adalat started spreading to other parts of the country. At that time, this institution was functioning as a voluntary and conciliatory agency without any statutory backing for its decisions. In view of its growing popularity, there arose a demand for providing a statutory backing to this institution and the awards given by Lok Adalats. Hence, the institution of Lok Adalat has been given statutory status under the Legal Services Authorities Act, 1987. The Act makes the following provisions relating to the organization and functioning of the Lok Adalats. 1. The State Legal Services Authority or the District Legal Services Authority or the Supreme Court Legal Services Committee or the High Court Legal Services Committee or the Taluk Legal Services Committee may organize Lok Adalats at such intervals and places and for exercising such jurisdiction and for such areas as it thinks fit. 2. Every Lok Adalat organized for an area shall consist of such number of serving or retired judicial officers and other persons of the area as may be specified by the agency organizing such Lok Adalat. Generally, a Lok Adalat consists of a judicial officer as the chairman and a lawyer, advocate, and a social worker as members. 3. A Lok Adalat shall have jurisdiction to determine and to arrive at a compromise or settlement between the parties to a dispute in respect of any case pending before any court, or 2. Any matter which is falling within the jurisdiction of any court and is not brought before such court. Thus, the Lok Adalat can deal with not only the cases pending before a court but also with the disputes at pre-litigation stage. Matters such as matrimonial family disputes, criminal, compoundable offences, cases, land acquisition cases, labour disputes, workmen's compensation cases, bank recovery cases, pension cases, housing board and slum clearance cases, housing finance cases, consumer grievance cases, electricity matters, disputes relating to telephone bills, municipal matters including house tax cases, disputes with cellular companies etc. are being taken up in Lok Adalats. But the Lok Adalat shall have no jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. In other words, the offences which are non-compoundable under any law fall outside the purview of the Lok Adalat. 4. Any case pending before the court can be referred to the Lok Adalat for settlement if the parties thereof agree to settle the dispute in the Lok Adalat, or 2. One of the parties thereof makes an application to the court for referring the case to the Lok Adalat, or 3. The court is satisfied that the matter is an appropriate one to be taken cognizance of by the Lok Adalat. In the case of a pre-litigation dispute, the matter can be referred to the Lok Adalat for settlement by the agency organizing the Lok Adalat on receipt of an application from any one of the parties to the dispute. 5. The Lok Adalat shall have the same powers as are vested in a civil court under the Code of Civil Procedure, 1908, while trying a suit in respect of the following matters. A. The summoning and enforcing the attendance of any witness examining him on oath. B. The discovery and production of any document. C. The reception of evidence on affidavits. D. The requisitioning of any public record or document from any court or office, and E. Such other matters as may be prescribed. Further, a Lok Adalat shall have the requisite powers to specify its own procedure for the determination of any dispute coming before it. Also, all proceedings before a Lok Adalat shall be deemed to be judicial proceedings within the meaning of the Indian Penal Code, 1860, and every Lok Adalat shall be deemed to be a civil court for the purpose of the Code of Criminal Procedure, 1973. 6. An award of a Lok Adalat shall be deemed to be a decree of a civil court or an order of any other court. Every award made by a Lok Adalat shall be final and binding on all the parties to the dispute. No appeal shall lie to any court against the award of the Lok Adalat. Benefits. According to the Supreme Court, the benefits under Lok Adalat are as follows. 1. There is no court fee, and if court fee is already paid, the amount will be refunded if the dispute is settled at Lok Adalat. 2. The basic features of Lok Adalat are the procedural flexibility and speedy trial of the disputes. There is no strict application of procedural laws like the Civil Procedure Code and the Evidence Act while assessing the claim by Lok Adalat. 3. The parties to the dispute can directly interact with the judge through their counsel, which is not possible in regular courts of law. 4. The award by the Lok Adalat is binding on the parties and it has the status of a decree of a civil court and it is non-appealable, which does not cause the delay in the settlement of disputes finally. In view of above facilities provided by the Act, Lok Adalats are boon to the litigating public as they can get their disputes settled fast and free of cost amicably. The Law Commission of India summarized the advantages of ADR, alternative dispute resolution, in the following way. 1. It is less expensive. 2. It is less time-consuming. 3. It is free from technicalities vis-à-vis conducting of cases in law courts. 4. Parties are free to discuss their differences of opinion without any fear of disclosure before any law courts. 5. Parties have the feeling that there is no losing or winning side between them, but at the same time their grievance is redressed and their relationship is restored. Permanent Lok Adalats. The Legal Services Authorities Act, 1987, was amended in 2002 to provide for the establishment of the permanent Lok Adalats to deal with cases pertaining to the public utility services. Reasons. The reasons for the establishment of permanent Lok Adalats are as follows. 1. The Legal Services Authorities Act, 1987 was enacted to constitute legal services authorities for providing free and competent legal services to the weaker sections of the society to ensure that opportunities for securing justice were not denied to any citizen by reason of economic or other disabilities, and to organize Lok Adalats to ensure that the operation of the legal system promotes justice on a basis of equal opportunity. 2. The system of Lok Adalat, which is an innovative mechanism for alternate dispute resolution, has proved effective for resolving disputes in a spirit of conciliation outside the courts. 3. However, the major drawback in the existing scheme of organization of the Lok Adalats under the said Act is that the system of Lok Adalats is mainly based on compromise or settlement between the parties. If the parties do not arrive at any compromise or settlement, the case is either returned to the court of law or the parties are advised to seek remedy in a court of law. This causes unnecessary delay in the dispensation of justice. If Lok Adalats are given power to decide the cases on merits in case parties fails to arrive at any compromise or settlement, this problem can be tackled to a great extent. 4. Further, the cases which arise in relation to public utility services such as Mahanagar Telephone Nigam Limited, Delhi Vidyut Board, etc., need to be settled urgently so that people get justice without delay even at pre-litigation stage, and thus most of the petty cases which ought not to go in the regular courts would be settled at the pre-litigation stage itself, which would result in reducing the workload of the regular courts to a great extent. 5. It is, therefore, proposed to amend the Legal Services Authorities Act, 1987 to set up permanent Lok Adalats for providing compulsory pre-litigative mechanism for conciliation and settlement of cases relating to public utility services. Features. The salient features of the new institution of permanent Lok Adalats are as follows. 1. The permanent Lok Adalat shall consist of a chairman who is or has been a district judge or additional district judge or has held judicial office higher in rank than that of the district judge, and two other persons having adequate experience in public utility services. 2. The permanent Lok Adalat shall exercise jurisdiction in respect of one or more public utility services such as transport services of passengers or goods by air, road and water, postal, telegraph or telephone services, supply of power, light or water to the public by any establishment, public conservancy or sanitation, services in hospitals or dispensaries, and insurance services. 3. The pecuniary jurisdiction of the permanent Lok Adalat shall be up to Rs 10 lakhs. However, the central government may increase the said pecuniary jurisdiction from time to time. 4. The permanent Lok Adalat shall have not jurisdiction in respect of any matter relating to an offence not compoundable under any law. 5. Before the dispute is brought before any court, any party to the dispute may make an application to the permanent Lok Adalat for settlement of the dispute. After an application is made to the permanent Lok Adalat, no party to that application shall invoke jurisdiction of any court in the same dispute. 6. Where it appears to the permanent Lok Adalat that there exist elements of a settlement which may be acceptable to the parties, it shall formulate the terms of a possible settlement and submit them to the parties for their observations, and in case the parties reach an agreement, the permanent Lok Adalat shall pass an award in terms thereof. In case parties to the dispute fail to reach an agreement, the permanent Lok Adalat shall decide the dispute on merits. 7. Every award made by the permanent Lok Adalat shall be final and binding on all the parties thereto and shall be by a majority of the persons constituting the permanent Lok Adalat. Family Courts. The Family Courts Act, 1984 was enacted to provide for the establishment of family courts with a view to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs. Reasons. The reasons for the establishment of separate family courts are as follows. 1. Several associations of women, other organizations and individuals have urged from time to time that family courts be set up for the settlement of family disputes, where emphasis should be laid on conciliation and achieving socially desirable results, and adherence to rigid rules of procedure and evidence should be eliminated. 2. The Law Commission in its 59th report, 1974, had also stressed that in dealing with disputes concerning the family, the court ought to adopt an approach radically different from the adopted in ordinary civil proceedings, and that it should make reasonable efforts at settlement before the commencement of the trial. The Code of Civil Procedure was amended in 1976 to provide for a special procedure to be adopted in suits or proceedings relating to matters concerning the family. 3. However, not much use has been made by the courts in adopting this conciliatory procedure, and the courts continue to deal with family disputes in the same manner as other civil matters, and the same adversary approach prevails. The need was, therefore, felt, in the public interest, to establish family courts for speedy settlement of family disputes. Therefore, the main objectives and reasons for setting up of family courts are: 1. To create a specialized court which will exclusively deal with family matters so that such a court may have the necessary expertise to deal with these cases expeditiously. Thus, expertise and expeditious disposal are two main factors for establishing such a court. 2. To institute a mechanism for conciliation of the disputes relating to family. 3. To provide an inexpensive remedy, and 4. To have flexibility and an informal atmosphere in the conduct of proceedings. Features. The salient features of the Family Courts Act, 1984 are as follows. 1. It provides for the establishment of family courts by the state governments in consultation with the high courts. 2. It makes it obligatory on the state governments to set up a family court in every city or town with a population exceeding 1 million. 3. It enables the state governments to set up family courts in other areas also if they deem it necessary. 4. It exclusively provides within the jurisdiction of the family courts the matters relating to I. Matrimonial relief, including nullity of marriage, judicial separation, divorce, restitution of conjugal rights, or declaration as to the validity of marriage or as to the matrimonial status of any person. 2. The property of the spouses or of either of them. 3. Declaration as to the legitimacy of any person. 4. Guardianship of a person or the custody of any minor and maintenance of wife, children and parents. 5. It makes it obligatory on the part of the family court to endeavor, in the first instance, to effect a reconciliation or a settlement between the parties to a family dispute. During this stage, the proceedings will be informal and rigid rules of procedure shall not apply. 6. It provides for the association of social welfare agencies, counselors, etc. during conciliation stage and also to secure the service of medical and welfare experts. 7. It provides that the parties to a dispute before a family court shall not be entitled, as of right, to be represented by legal practitioner. However, the court may, in the interest of justice, seek assistance of a legal expert as amicus curiae. 8. It simplifies the rules of evidence and procedure so as to enable a family court to deal effectively with a dispute. 9. It provides for only one right of appeal which shall lie to the High Court. Gram Nyayalayas. The Gram Nyayalayas Act 2008 has been enacted to provide for the establishment of the Gram Nyayalayas at the grassroots level for the purposes of providing access to justice to the citizens at their doorsteps and to ensure that opportunities for securing justice are not denied to any citizen due to social, economic or other disabilities. Reasons. The reasons for the establishment of Gram Nyayalayas are as follows. 1. Access to justice by the poor and disadvantaged remains a worldwide problem despite diverse approaches and strategies that have been formulated and implemented to address it. In our country, Article 39 of the Constitution directs the state to secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall provide free legal aid to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. 2. In the recent past, the government has taken various measures to strengthen judicial system, inter alia, by simplifying the procedural laws, incorporating various alternative dispute resolution mechanisms such as arbitration, conciliation and mediation, conducting of lok adalats, etc. These measures are required to be strengthened further. 3. The Law Commission of India in its 114th report on Gram Nyayalaya suggested establishment of Gram Nyayalayas so that speedy, inexpensive and substantial justice could be provided to the common man. The Gram Nyayalayas Act 2008 is broadly based on the recommendations of the Law Commission. 4. Justice to the poor at their doorstep is a dream of the poor. Setting up of Gram Nyayalayas in the rural areas would bring to the people of rural areas speedy, affordable and substantial justice. Features. The salient features of the Gram Nyayalayas Act are as follows. 1. The Gram Nyayalaya shall be court of judicial magistrate of the first class and its presiding officer, Nyayadhikari, shall be appointed by the state government in consultation with the High Court. 2. The Gram Nyayalay shall be established for every panchayat at intermediate level or a group of contiguous panchayats at intermediate level in a district or where there is no panchayat at intermediate level in any state for a group of contiguous panchayats. 3. The Nyayadhikaris who will preside over these Gram Nyayalayas are strictly judicial officers and will be drawing the same salary, deriving the same powers as first-class magistrates working under high courts. 4. The Gram Nyayalay shall be a mobile court and shall exercise the powers of both criminal and civil courts. 5. The seat of the Gram Nyayalay will be located at the headquarters of the intermediate panchayat. They will go to villages, work there and dispose of the cases. 6. The Gram Nyayalay shall try criminal cases, civil suits, claims or disputes which are specified in the first schedule and the second schedule to the Act. 7. The central as well as the state governments have been given power to amend the first schedule and the second schedule of the Act as per their respective legislative competence. 8. The Gram Nyayalay shall follow summary procedure in criminal trial. 9. The Gram Nyayalay shall exercise the powers of a civil court with certain modifications and shall follow the special procedure as provided in the Act. 10. The Gram Nyayalay shall try to settle the disputes as far as possible by bringing about conciliation between the parties, and for this purpose, it shall make use of the conciliators to be appointed for this purpose. 11. The judgment and order passed by the Gram Nyayalay shall be deemed to be a decree, and to avoid delay in its execution, the Gram Nyayalay shall follow summary procedure for its execution. 12. The Gram Nyayalay shall not be bound by the rules of evidence provided in the Indian Evidence Act 1872 but shall be guided by the principles of natural justice and subject to any rule made by the High Court. 13. Appeal in criminal cases shall lie to the Court of Session, which shall be heard and disposed of within a period of 6 months from the date of filing of such appeal. 14. Appeal in civil cases shall lie to the District Court, which shall be heard and disposed of within a period of 6 months from the date of filing of the appeal. 15. A person accused of an offence may file an application for plea bargaining. Establishment. The central government has decided to meet the non-recurring expenditure on the establishment of these Gram Nyayalayas subject to a ceiling of 18 lakhs rupees, out of which 10 lakhs rupees is for construction of the court, 5 lakhs rupees for vehicle and 3 lakhs rupees for office equipment. More than 5,000 Gram Nyayalayas are expected to be set up under the Act, for which the central government would provide about 1,400 crores rupees by way of assistance to the concerned states' union territories. Under of the Gram Nyayalayas Act 2008, it is for the state governments to establish Gram Nyayalayas in consultation with the respective high courts. Majority of states have now set up regular courts at taluka level. Further, reluctance of police officials and other state functionaries to invoke jurisdiction of Gram Nyayalayas, lukewarm response of the bar, non-availability of notaries and stamp vendors, problem of concurrent jurisdiction of regular courts are other issues indicated by the states which are coming in the way of operationalization of the Gram Nyayalayas. The issues affecting operationalization of the Gram Nyayalayas were discussed in the Conference of Chief Justices of High Courts and Chief Ministers of the states in April 2013. It was decided in the conference that the state government and High Court should decide the question of establishment of Gram Nyayalayas wherever feasible, taking into account their local problems. The focus is on setting up Gram Nyayalayas in the talukas where regular courts have not been set up. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. Laxmikanth, Indian Polity. Chapter 37. Special Provisions for Some States. Articles 371 to 371J in Part 21 of the Constitution contain special provisions for 12 states viz. Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka. The intention behind them is to meet the aspirations of the people of backward regions of the states or to protect the cultural and economic interests of the tribal people of the states or to deal with the disturbed law and order condition in some parts of the states or to protect the interests of the local people of the states. Originally, the Constitution did not make any special provisions for these states. They have been incorporated by the various subsequent amendments made in the context of reorganization of the states or conferment of statehood on the union territories. Provisions for Maharashtra and Gujarat. Under Article 371, the President is authorized to provide that the Governor of Maharashtra and that of Gujarat would have special responsibility for 1. The establishment of separate development boards for 1. Vidarbha, Marathwada and the rest of Maharashtra, 2. Saurashtra, Kutch and the rest of Gujarat. 2. Making a provision that a report on the working of these boards would be placed every year before the State Legislative Assembly. 3. The equitable allocation of funds for developmental expenditure over the above-mentioned areas and 4. An equitable arrangement providing adequate facilities for technical education and vocational training and adequate employment opportunities in the state services in respect of the above-mentioned areas. Provisions for Nagaland. Article 371-A makes the following special provisions for Nagaland. 1. The Acts of Parliament relating to the following matters would not apply to Nagaland unless the State Legislative Assembly so decides. 1. Religious or social practices of the Nagas. 2. Naga customary law and procedure. 3. Administration of civil and criminal justice involving decisions according to Naga customary law. And 4. Ownership and transfer of land and its resources. 2. The Governor of Nagaland shall have special responsibility for law and order in the state so long as internal disturbances caused by the hostile Nagas continue. In the discharge of this responsibility, the Governor, after consulting the Council of Ministers, exercises his individual judgment and his decision is final. This special responsibility of the Governor shall cease when the President so directs. 3. The Governor has to ensure that the money provided by the central government for any specific purpose is included in the demand for a grant relating to that purpose and not in any other demand moved in the State Legislative Assembly. 4. A regional council consisting of 35 members should be established for the Tuensang district of the state. The Governor should make rules for the composition of the council, manner of choosing its members. 5. Their qualifications, term, salaries and allowances, the procedure and conduct of business of the council, the appointment of officers and staff of the council and their service conditions, and any other matter relating to the constitution and proper functioning of the council. 5. For a period of 10 years from the formation of Nagaland or for such further period as the Governor may specify on the recommendation of the Regional Council, the following provisions would be operative for the Tuensang district. 1. The administration of the Tuensang district shall be carried on by the Governor. 2. The Governor shall in his discretion arrange for equitable distribution of money provided by the centre between Tuensang district and the rest of Nagaland. 3. Any act of Nagaland legislature shall not apply to Tuensang district unless the Governor so directs on the recommendation of the Regional Council. 4. The governor can make regulations for the peace, progress and good government of the Tuensang district. Any such regulation may repeal or amend an act of parliament or any other law applicable to that district. 5. There shall be a minister for Tuensang affairs in the State Council of Ministers. He is to be appointed from amongst the members representing Tuensang district in the Nagaland Legislative Assembly. 6. The final decision on all matters relating to Tuensang district shall be made by the governor in his discretion. 7. Members in the Nagaland Legislative Assembly from the Tuensang district are not elected directly by the people but by the regional council. Provisions for Assam and Manipur. Assam. Under Article 371B, the President is empowered to provide for the creation of a committee of the Assam Legislative Assembly consisting of the members elected from the tribal areas of the state and such other members as he may specify. Manipur. Article 371-C makes the following special provisions for Manipur. 1. The President is authorized to provide for the creation of a committee of the Manipur Legislative Assembly consisting of the members elected from the hill areas of the state. 2. The President can also direct that the Governor shall have special responsibility to secure the proper functioning of that committee. 3. The Governor should submit an annual report to the President regarding the administration of the hill areas. 4. The central government can give directions to the state government as to the administration of the hill areas. Provisions for Andhra Pradesh or Telangana. Articles 371D and 371E contain the special provisions for Andhra Pradesh. In 2014, Article 371D has been extended to the state of Telangana by the Andhra Pradesh Reorganization Act of 2014. Under Article 371D the following are mentioned. 1. The President is empowered to provide for equitable opportunities and facilities for the people belonging to different parts of the state in the matter of public employment and education, and different provisions can be made for various parts of the state. 2. For the above purpose, the President may require the state government to organize civil posts in local cadre for different parts of the state and provide for direct recruitment to posts in any local cadre. He may specify parts of the state which shall be regarded as the local area for admission to any educational institution. He may also specify the extent and manner of preference or reservation given in the matter of direct recruitment to posts in any such cadre or admission to any such educational institution. 3. The President may provide for the establishment of an administrative tribunal in the state to deal with certain disputes and grievances relating to appointment, allotment or promotion to civil posts in the state. The tribunal is to function outside the purview of the State High Court. No court, other than the Supreme Court, is to exercise any jurisdiction in respect of any matter subject to the jurisdiction of the tribunal. The President may abolish the tribunal when he is satisfied that its continued existence is not necessary. Article 371E empowers the Parliament to provide for the establishment of a central university in the state of Andhra Pradesh. Provisions for Sikkim. The 36th Constitutional Amendment Act of 1975 made Sikkim a full-fledged state of the Indian Union. It included a new Article 371F containing special provisions with respect to Sikkim. These are as follows. 1. The Sikkim Legislative Assembly is to consist of not less than 30 members. 2. 1 seat is allotted to Sikkim in the Lok Sabha, and Sikkim forms one parliamentary constituency. 3. For the purpose of protecting the rights and interests of the different sections of the Sikkim population, the Parliament is empowered to provide for the 1. Number of seats in the Sikkim Legislative Assembly which may be filled by candidates belonging to such sections, and 2. Delimitation of the assembly constituencies from which candidates belonging to such sections alone may stand for election to the assembly. 4. The governor shall have special responsibility for peace and for an equitable arrangement for ensuring the social and economic advancement of the different sections of the Sikkim population. In the discharge of this responsibility, the governor shall act in his discretion, subject to the directions issued by the President. 5. The President can extend, with restrictions or modifications, to Sikkim any law which is in force in a state of the Indian Union. Provisions for Mizoram. Article 371G specifies the following special provisions for Mizoram. 1. The Acts of Parliament relating to the following matters would not apply to Mizoram unless the State Legislative Assembly so decides. 1. Religious or social practices of the Mizos. 2. Mizo customary law and procedure. 3. Administration of civil and criminal justice involving decisions according to Mizo customary law. And 4. Ownership and transfer of land. 2. The Mizoram Legislative Assembly is to consist of not less than 40 members. Provisions for Arunachal Pradesh and Goa. Arunachal Pradesh. Under Article 371H, the following special provisions are made for Arunachal Pradesh. 1. The Governor of Arunachal Pradesh shall have special responsibility for law and order in the state. In the discharge of this responsibility, the Governor, after consulting the Council of Ministers, exercises his individual judgment and his decision is final. This special responsibility of the Governor shall cease when the President so directs. 2. The Arunachal Pradesh Legislative Assembly is to consist of not less than 30 members. Goa. Article 371I provides that the Goa Legislative Assembly is to consist of not less than 30 members. Provisions for Karnataka. Under Article 371J, the President is empowered to provide that the Governor of Karnataka would have special responsibility for 1. The establishment of a separate development board for Hyderabad Karnataka region. 2. Making a provision that a report on the working of the board would be placed every year before the State Legislative Assembly. 3. The equitable allocation of funds for developmental expenditure over the region. 4. The reservation of seats in educational and vocational training institutions in the region for students who belong to the region. 5. The reservation in state government posts in the region for persons who belong to the region. Article 371J, which provided for special provisions for the Hyderabad Karnataka region of the state of Karnataka, was inserted in the Constitution by the 98th Constitutional Amendment Act of 2012. The special provisions aim to establish an institutional mechanism for equitable allocation of funds to meet the development needs over the region, as well as to enhance human resources and promote employment from the region by providing for local cadre in service and reservation in educational and vocational training institutions. In 2010, the Legislative Assembly as well as the Legislative Council of Karnataka passed separate resolutions seeking special provisions for the Hyderabad Karnataka region of the state of Karnataka. The government of Karnataka also endorsed the need for special provisions for the region. The resolutions sought to accelerate development of the most backward region of the state and promote inclusive growth with a view to reducing inter-district and inter-regional disparities in the state. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. M. Laxmikanth, Indian Polity. Chapter 38. Panchayati Raj. The term Panchayati Raj in India signifies the system of rural local self-government. It has been established in all the states of India by the acts of the state legislatures to build democracy at the grassroots level. It is interested with rural development. It was constitutionalized through the 73rd Constitutional Amendment Act of 1992. Evolution of Panchayati Raj. Balwant Rai Mehta Committee. In January 1957, the Government of India appointed a committee to examine the working of the Community Development Programme 1952 and the National Extension Service 1953 and to suggest measures for their better working. The chairman of this committee was Balwant Rai Ji Mehta. The committee submitted its report in November 1957 and recommended the establishment of the scheme of democratic decentralization, which ultimately came to be known as Panchayati Raj. The specific recommendations made by it are: 1. Establishment of a three-tier Panchayati Raj system, Gram Panchayat at the village level, Panchayat Samiti at the block level and Zilla Parishad at the district level. These tiers should be organically linked through a device of indirect elections. 2. The village panchayat should be constituted with directly elected representatives, whereas the Panchayat Samiti and Zilla Parishad should be constituted with indirectly elected members. 3. All planning and development activities should be entrusted to these bodies. 4. The Panchayat Samiti should be the executive body while the Zilla Parishad should be the advisory, coordinating and supervisory body. 5. The district collector should be the chairman of the Zilla Parishad. 6. There should be a genuine transfer of power and responsibility to these democratic bodies. 7. Adequate resources should be transferred to these bodies to enable them to discharge their functions and fulfill their responsibilities. 8. A system should be evolved to effect further devolution of authority in future. These recommendations of the committee were accepted by the National Development Council in January 1958. The council did not insist on a single rigid pattern and left it to the states to evolve their own patterns suitable to local conditions. But the basic principles and broad fundamentals should be identical throughout the country. Rajasthan was the first state to establish Panchayati Raj. The scheme was inaugurated by the Prime Minister on 2 October 1959 in Nagaur district. Rajasthan was followed by Andhra Pradesh, which also adopted the system in 1959. Thereafter, most of the states adopted the system. Though most of the states created Panchayati Raj institutions by mid-1960s, as there were differences from one state to another with regard to the number of tiers, relative position of Samiti and Parishad, their tenure, composition, functions, finances and so on. For example, Rajasthan adopted the three-tier system while Tamil Nadu adopted the two-tier system. West Bengal, on the other hand, adopted the four-tier system. Further, in the Rajasthan-Andhra Pradesh pattern, Panchayat Samiti was powerful as the block was the unit of planning and development, while in Maharashtra-Gujarat pattern, Zilla Parishad was powerful as the district was the unit of planning and development. Some states also established Nyaya Panchayats, that is, judicial panchayats to try petty civil and criminal cases. Study teams and committees. Since 1960, many study teams, committees, and working groups have been appointed to examine the various aspects of functioning of Panchayati Raj system. Ashok Mehta Committee. In December 1977, the Janata government appointed a committee on Panchayati Raj institutions under the chairmanship of Ashok Mehta. It submitted its report in August 1978 and made 132 recommendations to revive and strengthen the declining Panchayati Raj system in the country. Its main recommendations were: 1. The three-tier system of Panchayati Raj should be replaced by the two-tier system, that is, Zilla Parishad at the district level, and below it, the Mandal Panchayat consisting of a group of villages with a total population of 15,000 to 20,000. 2. A district should be the first point for decentralization under popular supervision below the state level. 3. Zilla Parishad should be the executive body and made responsible for planning at the district level. 4. There should be an official participation of political parties at all levels of Panchayat elections. 5. The Panchayati Raj institutions should have compulsory powers of taxation to mobilize their own financial resources. 6. There should be a regular social audit by a district-level agency and by a committee of legislators to check whether the funds allotted for the vulnerable social and economic groups are actually spent on them. 7. The state government should not supersede the Panchayati Raj institutions. In case of an imperative supersession, elections should be held within 6 months from the date of supersession. 8. The Nyaya Panchayats should be kept as separate bodies from that of development panchayats. They should be presided over by a qualified judge. 9. The Chief Electoral Officer of a state in consultation with the Chief Election Commissioner should organize and conduct the Panchayati Raj elections. 10. Development functions should be transferred to the Zilla Parishad and all development staff should work under its control and supervision. 11. The voluntary agencies should play an important role in mobilizing the support of the people for Panchayati Raj. 12. A minister for Panchayati Raj should be appointed in the State Council of Ministers to look after the affairs of the Panchayati Raj institutions. 13. Seats for SCs and STs should be reserved on the basis of their population. 14. A constitutional recognition should be accorded to the Panchayati Raj institutions. This would give them the requisite status, sanctity and stature, and an assurance of continuous functioning. Due to the collapse of the Janata government before the completion of its term, no action could be taken on the recommendations of the Ashok Mehta Committee at the central level. However, the three states of Karnataka, West Bengal and Andhra Pradesh took steps to revitalize the Panchayati Raj, keeping in view some of the recommendations of the Ashok Mehta Committee. G.V.K. Rao Committee. The committee to review the existing administrative arrangements for rural development and poverty alleviation programs under the chairmanship of G.V.K. Rao was appointed by the Planning Commission in 1985. The committee came to conclusion that the developmental process was gradually bureaucratized and divorced from the Panchayati Raj. This phenomena of bureaucratization of development administration as against the democratization weakened the Panchayati Raj institutions, resulting in what is aptly called as grass without roots. Hence, the committee made the following recommendations to strengthen and revitalize the Panchayati Raj system. 1. The district-level body, that is, the Zilla Parishad should be of pivotal importance in the scheme of democratic decentralization. It stated that the district is the proper unit for planning and development and the Zilla Parishad should become the principal body for management of all development programs which can be handled at that level. 2. The Panchayati Raj institutions at the district and lower levels should be assigned an important role with respect to planning, implementation and monitoring of rural development programs. 3. Some of the planning functions at the state level should be transferred to the district-level planning units for effective decentralized district planning. 4. A post of District Development Commissioner should be created. He should act as the Chief Executive Officer of the Zilla Parishad and should be in charge of all the development departments at the district level. 5. Elections to the Panchayati Raj institutions should be held regularly. It found that elections became overdue for one or more tiers in 11 states. Thus the committee, in its scheme of decentralized system of field administration, assigned a leading role to the Panchayati Raj in local planning and development. It is in this respect that the recommendation of the G.V.K. Rao Committee Report, 1986, differed from those of the Dantawala Committee Report on Block-Level Planning, 1978, and the Hanumanta Rao Committee Report on District Planning, 1984. Both the committees have suggested that the basic decentralized planning function should be done at the district level. The Hanumanta Rao Committee advocated separate district planning bodies under either the district collector or a minister. In both the models, the collector should play a significant role in the decentralized planning, though the committee stated that Panchayati Raj institutions would also be associated with this process of decentralized planning. The committee recommended that the collector should be the coordinator at the district level of all developmental and planning activities. Thus the Hanumanta Rao Committee differed in this respect from those of Balwantre Mehta Committee, the Administrative Reforms Commission of India, the Ashok Mehta Committee, and finally the G.V.K. Rao Committee, which recommended reduction in the developmental role of the district collector and which assigned a major role to the Panchayati Raj in development administration. L.M. Singhvi Committee. In 1986, Rajiv Gandhi government appointed a committee to prepare a concept paper on revitalization of Panchayati Raj institutions for democracy and development under the chairmanship of L.M. Singhvi. It made the following recommendations. 1. The Panchayati Raj institutions should be constitutionally recognized, protected and preserved. For this purpose, a new chapter should be added in the Constitution of India. This will make their identity and integrity reasonably and substantially inviolate. It also suggested constitutional provisions to ensure regular, free and fair elections to the Panchayati Raj bodies. 2. Nyaya Panchayats should be established for a cluster of villages. 3. The villages should be reorganized to make Gram Panchayats more viable. It also emphasized the importance of the Gram Sabha and called it as the embodiment of direct democracy. 4. The village panchayats should have more financial resources. 5. The judicial tribunals should be established in each state to adjudicate controversies about election to the Panchayati Raj institutions, their dissolution and other matters related to their functioning. Thungo Committee. In 1988, a subcommittee of the Consultative Committee of Parliament was constituted under the chairmanship of P.K. Thungo to examine the political and administrative structure in the district for the purpose of district planning. This committee suggested for the strengthening of the Panchayati Raj system. It made the following recommendations. 1. The Panchayati Raj bodies should be constitutionally recognized. 2. A three-tier system of Panchayati Raj with panchayats at the village, block and district levels. 3. Jilla Parishad should be the pivot of the Panchayati Raj system. It should act as the planning and development agency in the district. 4. The Panchayati Raj bodies should have a fixed tenure of 5 years. 5. The maximum period of supersession of a body should be 6 months. 6. A planning and coordination committee should be set up at the state level under the chairmanship of the Minister for Planning. The presidents of Jilla Parishads should be its members. 7. A detailed list of subjects for Panchayati Raj should be prepared and incorporated in the Constitution. 8. Reservation of seats in all the 3 tiers should be on the basis of population. There should also be reservation for women. 9. A State Finance Commission should be set up in each state. It would lay down the criteria and guidelines for the devolution of finances to the Panchayati Raj institutions. 10. The district collector should be the chief executive officer of the Jilla Parishad. Gadgil Committee. The Committee on Policy and Programs was constituted in 1988 by the Congress Party under the chairmanship of V.N. Gadgil. This committee was asked to consider the question of how best Panchayati Raj institutions could be made effective. In this context, the committee made the following recommendations. 1. A constitutional status should be bestowed on the Panchayati Raj institutions. 2. A three-tier system of Panchayati Raj with panchayats at the village, block and district levels. 3. The term of Panchayati Raj institutions should be fixed at 5 years. 4. The members of the panchayats at all the three levels should be directly elected. 5. Reservation for SCs, STs and women. 6. The Panchayati Raj bodies should have the responsibility of preparation and implementation of plans for socio-economic development. For this purpose, a list of subjects should be specified in the Constitution. 7. The Panchayat Raj bodies should be empowered to levy, collect, and appropriate taxes and duties. 8. Establishment of a State Finance Commission for the allocation of finances to the panchayats. 9. Establishment of a State Election Commission for the conduction of elections to the panchayats. The above recommendations of the Gadgil Committee became the basis for drafting an amendment bill aimed at conferring the constitutional status and protection to the Panchayati Raj institutions. Constitutionalization. Rajiv Gandhi Government. The Rajiv Gandhi government introduced the 64th Constitutional Amendment Bill in the Lok Sabha in July 1989 to constitutionalize Panchayati Raj institutions and make them more powerful and broad-based. Although the Lok Sabha passed the bill in August 1989, it was not approved by the Rajya Sabha. The bill was vehemently opposed by the opposition on the ground that it sought to strengthen centralization in the federal system. V.P. Singh government. The National Front government, soon after assuming office in November 1989 under the Prime Ministership of V.P. Singh, announced that it would take steps to strengthen the Panchayati Raj institutions. In June 1990, a two-day conference of the state chief ministers under the chairmanship of V.P. Singh was held to discuss the issues relating to the strengthening of the Panchayati Raj bodies. The conference approved the proposals for the introduction of a fresh constitutional amendment bill. Consequently, a constitutional amendment bill was introduced in the Lok Sabha in September 1990. However, the fall of the government resulted in the lapse of the bill. Narasimha Rao government. The Congress government under the Prime Ministership of P.V. Narasimha Rao once again considered the matter of the constitutionalization of Panchayati Raj bodies. It drastically modified the proposals in this regard to delete the controversial aspects and introduced a constitutional amendment bill in the Lok Sabha in September 1991. This bill finally emerged as the 73rd Constitutional Amendment Act, 1992 and came into force on 24 April 1993. 73rd Amendment Act of 1992. Significance of the Act. This Act has added a new Part 9 to the Constitution of India. This part is entitled as the Panchayats and consists of provisions from Articles 243 to 243(o). In addition, the Act has also added a new 11th schedule to the Constitution. This schedule contains 29 functional items of the Panchayats. It deals with Article 243-G. The Act has given a practical shape to Article 40 of the Constitution, which says that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. This article forms a part of the directive principles of state policy. The Act gives a constitutional status to the Panchayati Raj institutions. It has brought them under the purview of the justiciable part of the Constitution. In other words, the state governments are under constitutional obligation to adopt the new Panchayati Raj system in accordance with the provisions of the Act. Consequently, neither the formation of panchayats nor the holding of elections at regular intervals depend on the will of the state government anymore. The provisions of the Act can be grouped into two categories: compulsory and voluntary. The compulsory, mandatory or obligatory provisions of the Act have to be included in the state laws creating the new Panchayati Raj system. The voluntary provisions, on the other hand, may be included at the discretion of the states. Thus, the voluntary provisions of the Act ensures the right of the states to take local factors like geographical, politico-administrative and others into consideration while adopting the new Panchayati Raj system. The Act is a significant landmark in the evolution of grassroots democratic institutions in the country. It transfers the representative democracy into participatory democracy. It is a revolutionary concept to build democracy at the grassroots level in the country. Salient features. The salient features of the Act are: Gram Sabha. The Act provides for a Gram Sabha as the foundation of the Panchayati Raj system. It is a body consisting of persons registered in the electoral rolls of a village comprised within the area of Panchayat at the village level. Thus, it is a village assembly consisting of all the registered voters in the area of a Panchayat. It may exercise such powers and perform such functions at the village level as the legislature of a state determines. Three-tier system. The Act provides for a three-tier system of Panchayati Raj in every state, that is, panchayats at the village, intermediate, and district levels. Thus, the Act brings about uniformity in the structure of Panchayati Raj throughout the country. However, a state having a population not exceeding 20 lakh may not constitute panchayats at the intermediate level. Election of members and chairpersons. All the members of panchayats at the village, intermediate and district levels shall be elected directly by the people. Further, the chairperson of panchayats at the intermediate and district levels shall be elected indirectly by and from amongst the elected members thereof. However, the chairperson of a panchayat at the village level shall be elected in such manner as the state legislature determines. The chairperson of a panchayat and other members of a panchayat elected directly or indirectly shall have the right to vote in the meetings of the panchayats. Reservation of seats. The Act provides for the reservation of seats for scheduled castes and scheduled tribes in every panchayat, i.e., at all the three levels, in proportion of their population to the total population in the panchayat area. Further, the state legislature shall provide for the reservation of offices of chairperson in the panchayat at the village or any other level for the SCs and STs. The Act provides for the reservation of not less than one-third of the total number of seats for women, including the number of seats reserved for women belonging to the SCs and STs. Further, not less than one-third of the total number of offices of chairpersons in the panchayats at each level shall be reserved for women. The Act also authorizes the legislature of a state to make any provision for reservation of seats in any panchayat or offices of chairperson in the panchayat at any level in favor of backward classes. The reservation of seats as well as the reservation of offices of chairpersons in the panchayats for the scheduled castes and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 70 years, that is, till 2020. It must be noted here that the above provision relating to the reservation of seats in panchayats, both members and chairpersons, for the scheduled castes is not applicable to the state of Arunachal Pradesh. This is because the state is inhabited fully by indigenous tribal people and there are no scheduled castes. This provision was added later by the 83rd Constitutional Amendment Act of 2000. Duration of Panchayats. The Act provides for a 5-year term of office to the Panchayat at every level. However, it can be dissolved before the completion of its term. Further, fresh elections to constitute a Panchayat shall be completed, a. before the expiry of its duration of 5 years, or b. in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But where the remainder of the period, for which the dissolved Panchayat would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new Panchayat for such period. Moreover, a Panchayat constituted upon the dissolution of a Panchayat before the expiration of its duration shall continue only for the remainder of the period for which the dissolved Panchayat would have continued had it not been so dissolved. In other words, a Panchayat reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. Disqualifications. A person shall be disqualified for being chosen as or for being a member of Panchayat if he is so disqualified, a. under any law for the time being in force for the purpose of elections to the legislature of the state concerned, or b. under any law made by the state legislature. However, no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Further, all questions of disqualifications shall be referred to such authority as the state legislature determines. State Election Commission. The superintendence, direction and control of the preparation of electoral rolls and the conduct of all elections to the panchayats shall be vested in the State Election Commission. It consists of a state election commissioner to be appointed by the governor. His conditions of service and tenure of office shall also be determined by the governor. He shall not be removed from the office except in the manner and on the grounds prescribed for the removal of a judge of the State High Court. His conditions of service shall not be varied to his disadvantage after his appointment. The state legislature may make provision with respect to all matters relating to elections to the panchayats. Powers and functions. The state legislature may endow the panchayats with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon panchayats at the appropriate level with respect to a. the preparation of plans for economic development and social justice, b. the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 29 matters listed in the 11th schedule. Finances. The state legislature may a. authorize a panchayat to levy, collect and appropriate taxes, duties, tolls and fees, b. assign to a panchayat taxes, duties, tolls and fees levied and collected by the state government, c. provide for making grants in aid to the panchayats from the consolidated fund of the state, and d. provide for constitution of funds for crediting all monies of the panchayats. Finance Commission. The governor of a state shall, after every 5 years, constitute a finance commission to review the financial position of the panchayats. It shall make the following recommendations to the governor. 1. The principles that should govern. A. The distribution between the state and the panchayats of the net proceeds of the taxes, duties, tolls and fees levied by the state and allocation of shares amongst the panchayats at all levels. B. The determination of taxes, duties, tolls and fees that may be assigned to the panchayats. C. The grants in aid to the panchayats from the consolidated fund of the state. 2. The measures needed to improve the financial position of the panchayats. 3. Any other matter referred to it by the governor in the interests of sound finance of the panchayats. The state legislature may provide for the composition of the commission, the required qualifications of its members and the manner of their selection. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats in the states on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by the panchayats and the auditing of such accounts. Application to Union Territories. The provisions of this part are applicable to the Union Territories. But the President may direct that they would apply to a Union Territory subject to such exceptions and modifications as he may specify. Exempted states and areas. The Act does not apply to the states of Nagaland, Meghalaya and Mizoram and certain other areas. These areas include a. the scheduled areas and the tribal areas in the states, b. the hill areas of Manipur for which district councils exist, and c. Darjeeling district of West Bengal for which Darjeeling Gorkha Hill Council exists. However, the Parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayats Extension to the Scheduled Areas Act, 1996, popularly known as the PSA Act or the Extension Act. Continuance of existing laws and Panchayats. All the state laws relating to Panchayats shall continue to be in force until the expiry of 1 year from the commencement of this Act. In other words, the states have to adopt the new Panchayati Raj system based on this Act within the maximum period of 1 year from 24th April 1993, which was the date of the commencement of this Act. However, all the Panchayats existing immediately before the commencement of Act shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Consequently, majority of states passed the Panchayati Raj Acts in 1993 and 1994 to adopt the new system in accordance with the 73rd Constitutional Amendment Act of 1992. Bar to interference by courts in electoral matters. The Act bars the interference by courts in the electoral matters of panchayats. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any panchayat is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 11th Schedule. It contains the following 29 functional items placed within the purview of panchayats. 1. Agriculture, including agricultural extension. 2. Land improvement, implementation of land reforms, land consolidation and soil conservation. 3. Minor irrigation, water management and watershed development. 4. Animal husbandry, dairying and poultry. 5. Fisheries. 6. Social forestry and farm forestry. 7. Minor forest produce. 8. Small-scale industries, including food processing industries. 9. Khadi, village and cottage industries. 10. Rural housing. 11. Drinking water. 12. Fuel and fodder. 13. Roads, culverts, bridges, ferries, waterways and other means of communication. 14. Rural electrification, including distribution of electricity. 15. Non-conventional energy sources. 16. Poverty alleviation program. 17. Education, including primary and secondary schools. 18. Technical training and vocational education. 19. Adult and non-formal education. 20. Libraries. 21. Cultural activities. 22. Markets and fairs. 23. Health and sanitation including hospitals, primary health centers and dispensaries. 24. Family welfare. 25. Women and child development. 26. Social welfare, including welfare of the handicapped and mentally retarded. 27. Welfare of the weaker sections, and in particular, of the scheduled castes and the scheduled tribes. 28. Public distribution system. 29. Maintenance of community assets. Thank you so much for watching this video. If this video helped you in any way, so please do like and share this video and hit the subscribe button. M. Laxmikanth, Indian Polity. Chapter 38. Panchayati Raj. Compulsory and voluntary provisions. Now, we will identify separately the compulsory, obligatory or mandatory, and voluntary, discretionary or optional, provisions, features of the 73rd Constitutional Amendment Act, 1992, or the Part 9 of the Constitution. A. Compulsory provisions. 1. Organization of Gram Sabha in a village or group of villages. 2. Establishment of panchayats at the village, intermediate and district levels. 3. Direct elections to all seats in panchayats at the village, intermediate and district levels. 4. Indirect elections to the post of chairperson of panchayats at the intermediate and district levels. 5. Voting rights of the chairperson and other members of a panchayat elected directly or indirectly. 6. 21 years to be the minimum age for contesting elections to panchayats. 7. Reservation of seats, both members and chairpersons, for SCs and STs in panchayats at all the three levels. 8. Reservation of 1/3 seats, both members and chairpersons, for women in panchayats at all the three levels. 9. Fixing tenure of 5 years for panchayats at all levels and holding fresh elections within 6 months in the event of supersession of any panchayat. 10. Establishment of a state election commission for conducting elections to the panchayats. 11. Constitution of a state finance commission after every 5 years to review the financial position of the panchayats. B. Voluntary provisions. 1. Endowing the Gram Sabha with powers and functions at the village level. 2. Determining the manner of election of the chairperson of the village panchayat. 3. Giving representation to the chairpersons of the village panchayats in the intermediate panchayats or, in the case of a state not having intermediate panchayats, in the district panchayats. 4. Giving representation to the chairpersons of the intermediate panchayats in the district panchayats. 5. Giving representation to members of the parliament, both the houses, and the state legislature, both the houses, in the panchayats at different levels falling within their constituencies. 6. Providing reservation of seats, both members and chairpersons, for backward classes in panchayats at any level. 7. Granting powers and authority to the panchayats to enable them to function as institutions of self-government, in brief, making them autonomous bodies. 8. Devolution of powers and responsibilities upon panchayats to prepare plans for economic development and social justice, and to perform some or all of the 29 functions listed in the 11th schedule of the Constitution. 9. Granting financial powers to the panchayats, that is, authorizing them to levy, collect and appropriate taxes, duties, tolls and fees. 10. Assigning to a panchayat the taxes, duties, tolls and fees levied and collected by the state government. 11. Making the grants in aid to the panchayats from the consolidated fund of the state. 12. Providing for constitution of funds for crediting all monies of the panchayats. PSA Act of 1996, Extension Act. The provisions of Part 9 of the Constitution relating to the panchayats are not applicable to the 5th Schedule areas. However, the Parliament may extend these provisions to such areas, subject to such exceptions and modifications as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayats, Extension to the Scheduled Areas, Act, 1996, popularly known as the PSA Act or the Extension Act. At present, 2019, 10 states have 5th Schedule areas. These are Andhra Pradesh, Telangana, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh, Maharashtra, Odisha and Rajasthan. All the 10 states have enacted requisite compliance legislations by amending the respective Panchayati Raj Acts. Objectives of the Act. The objectives of the PSA Act are as follows. 1. To extend the provisions of Part 9 of the Constitution relating to the panchayats to the scheduled areas with certain modifications. 2. To provide self-rule for the bulk of the tribal population. 3. To have village governance with participatory democracy and to make the Gram Sabha a nucleus of all activities. 4. To evolve a suitable administrative framework consistent with traditional practices. 5. To safeguard and to preserve the traditions and customs of tribal communities. 6. To empower panchayats at the appropriate levels with specific powers conducive to tribal requirements. 7. To prevent panchayats at the higher level from assuming the powers and authority of panchayats at the lower level of the Gram Sabha. Features of the Act. The features or the provisions of the PSA Act are as follows. 1. A state legislation on the panchayats in the scheduled areas shall be in consonance with the customary law, social and religious practices and traditional management practices of community resources. 2. A village shall ordinarily consist of a habitation or a group of habitations or a hamlet or a group of hamlets comprising a community and managing its affairs in accordance with traditions and customs. 3. Every village shall have a Gram Sabha consisting of persons whose names are included in the electoral rolls for the panchayat at the village level. 4. Every Gram Sabha shall be competent to safeguard and preserve the traditions and customs of the people, their cultural identity, community resources and the customary mode of dispute resolution. 5. Every Gram Sabha shall 1. Approve of the plans, programs and projects for social-economic development before they are taken up implementation by the panchayat at the village level and 2. Be responsible for the identification of beneficiaries under poverty alleviation and other programs. 6. Every panchayat at the village level shall be required to obtain from the Gram Sabha a certification of utilization of funds for the above plans, programs and projects. 7. The reservation of seats in the scheduled areas in every panchayat shall be in proportion to the population of the communities for whom reservation is sought to be given under Part 9 of the Constitution. However, the reservation for the scheduled tribes shall not be less than 1/2 of the total number of seats. Further, all seats of chairpersons of panchayats at all levels shall be reserved for the scheduled tribes. 8. The state government may nominate such scheduled tribes which have no representation in the panchayat at the intermediate level or the panchayat at the district level. But such nomination shall not exceed 1/10 of the total members to be elected in that panchayat. 9. The Gram Sabha or the panchayats at the appropriate level shall be consulted before making the acquisition of land in the scheduled areas for development projects and before resettling or rehabilitating persons affected by such projects in the scheduled areas. However, The actual planning and implementation of the projects in the scheduled areas shall be coordinated at the state level. 10. Planning and management of minor water bodies in the scheduled areas shall be entrusted to panchayats at the appropriate level. 11. The recommendations of the Gram Sabha or the panchayats at the appropriate level shall be mandatory for grant of prospecting license or mining lease for minor minerals in the scheduled areas. 12. The prior recommendation of the Gram Sabha or the panchayats at the appropriate level shall be mandatory for grant of concession for the exploitation of minor minerals by auction. 13. While endowing panchayats in the scheduled areas with such powers and authority as may be necessary to enable them to function as institutions of self-government, a state legislature shall ensure that the panchayats at the appropriate level and the Gram Sabha are endowed specifically with 1. The power to enforce prohibition or to regulate or restrict the sale and consumption of any intoxicant. 2. The ownership of minor forest produce. 3. The power to prevent alienation of land in the scheduled areas and to take appropriate action to restore any unlawfully alienated land of a scheduled tribe. 4. The power to manage village markets. 5. The power to exercise control over money lending to the scheduled tribes. 6. The power to exercise control over institutions and functionaries in all social sectors. 7. The power to control local plans and resources for such plans including tribal subplans. 14. The state legislations shall contain safeguards to ensure that panchayats at the higher level do not assume the powers and authority of any panchayat at the lower level or of the Gram Sabha. 15. The state legislature shall endeavour to follow the pattern of the 6th schedule to the constitution while designing the administrative arrangements in the panchayats at district levels in the scheduled areas. 16. Any provision of any law relating to panchayats in the scheduled areas which is inconsistent with the provisions of this Act shall cease to be in force at the expiry of 1 year from the date on which this Act receives the assent of the President. However, all the panchayats existing immediately before such date shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Finances of Panchayati Raj. The Second Administrative Reforms Commission of India, 2005 to 2009, has summarized the sources of revenue of the Panchayati Raj institutions, PRIs, and their financial problems in the following way. 1. A major portion of Part 9 of the Constitution deals with structural empowerment of the PRIs, but the real strength in terms of both autonomy and efficiency of these institutions is dependent on their financial position, including their capacity to generate own resources. In general, panchayats in our country receive funds in the following ways. 1. Grants from the Union Government based on the recommendations of the Central Finance Commission as per Article 280 of the Constitution. 2. Devolution from the State Government based on the recommendations of the State Finance Commission as per Article 243 first. 3. Loans grants from the State Government. 4. Program-specific allocation under centrally sponsored schemes and additional central assistance. 5. Internal resource generation, tax and non-tax. 2. Across the country, states have not given adequate attention to fiscal empowerment of the panchayats. The panchayats' own resources are meager. Kerala, Karnataka and Tamil Nadu are the states which are considered to be progressive in PRI's empowerment, but even there, the panchayats are heavily dependent on government grants. One can draw the following broad conclusions. 1. Internal resource generation at the panchayat level is weak. This is partly due to a thin tax domain and partly due to panchayats' own reluctance in collecting revenue. 2. Panchayats are heavily dependent on grants from union and state governments. 3. A major portion of the grants both from union as well as the state governments is scheme-specific. Panchayats have limited discretion and flexibility in incurring expenditure. 4. In view of their own tight fiscal position, state governments are not keen to devolve funds to panchayats. 5. In most of the critical 11th schedule matters like primary education, healthcare, water supply, sanitation and minor irrigation, even now, it is the state government which is directly responsible for implementation of these programs and hence expenditure. 6. Overall, a situation has been created where panchayats have responsibility but grossly inadequate resources. 3. Though, in absolute terms, the quantum of funds the union state government transfers to a panchayat forms the major component of its receipt, the PRI's own resource generation is the soul behind its financial standing. It is not only a question of resources, it is the existence of a local taxation system which ensures people's involvement in the affairs of an elected body. It also makes the institution accountable to its citizens. 4. In terms of own resource collection, the Gram Panchayats are comparatively in a better position because they have a tax domain of their own, while the other two tiers are dependent only on tolls, fees and non-tax revenue for generating internal resources. 5. State Panchayati Raj Acts have given most of the taxation powers to village panchayats. The revenue domain of the intermediate and district panchayats, both tax as well as non-tax, has been kept much smaller and remains confined to secondary areas like ferry services, markets, water and conservancy services, registration of vehicles, cess on stamp duty and a few others. 6. A study of various state legislations indicates that a number of taxes, duties, tolls and fees come under the jurisdiction of the village panchayats. These inter alia include octroi, property house tax, profession tax, land tax cess, taxes tolls on vehicles, entertainment tax fees, license fees, tax on non-agriculture land, fee on registration of cattle, sanitation drainage conservancy tax, water rate tax, lighting rate tax, education cess, and tax on fairs and festivals. Reasons for ineffective performance. Even after conferring the constitutional status and protection through the 73rd Amendment Act, 1992, the performance of the Panchayati Raj institutions, PRIs, has not been satisfactory and not up to the expected level. The various reasons for this suboptimal performance are as follows. 1. Lack of adequate devolution. Many states have not taken adequate steps to devolve 3 Fs, i.e., functions, funds and functionaries, to the PRIs to enable them to discharge their constitutionally stipulated function. Further, it is imperative that the PRIs have resources to match the responsibilities entrusted to them. While SFCs, State Finance Commissions, have submitted their recommendations, not many few states have implemented these or taken steps to ensure the fiscal viability of the PRIs. 2. Excessive control by bureaucracy. In some states, the Gram Panchayats have been placed in a position of subordination. Hence, the Gram Panchayat Sarpanches have to spend extraordinary amount of time visiting block offices for funds and or technical approval. These interactions with the block staff office distort the role of Sarpanches as elected representatives. 3. Tied nature of funds. This has two implications. The activities stated under a certain scheme are not always appropriate for all parts of the district. This results in unsuitable activities being promoted or an underspend of the funds. 4. Overwhelming dependency on government funding. A review of money received and own source funds shows the overwhelming dependence of panchayats on government funding. When panchayats do not raise resources and instead receive funds from outside, people are less likely to request a social audit. 5. Reluctance to use fiscal powers. An important power devolved to GP, Gram Panchayat, is the right to levy tax on property, business, markets, fairs and also for services provided, like street lighting or public toilets, etc. Very few panchayats use their fiscal power to levy and collect taxes. The argument pushed by panchayat heads is that it is difficult to levy tax on your own constituency, especially when you live in the community. 6. Status of the Gram Sabha. Empowering the Gram Sabhas could have been a powerful weapon for transparency, accountability and for involvement of the marginalized sections. However, a number of the state acts have not spelt the powers of Gram Sabhas nor have any procedures been laid down for the functioning of these bodies or penalties for the officials. 7. Creation of parallel bodies. Often, parallel bodies, PBs, are created for supposedly speedy implementation and greater accountability. However, there is little evidence to show that such PBs have avoided the evils including that of partisan politics, sharing of spoils, corruption and elite capture. Missions, in particular, often bypassing mainstream programs, create disconnect, duality and alienation between the existing and the new structures and functions. PBs usurp the legitimate space of PRIs and demoralize the PRIs by virtue of their superior resource endowments. 8. Poor infrastructure. A large number of Gram Panchayats in the country do not have even full-time secretary. Around 25% of the Gram Panchayats do not have basic office buildings. The database for planning, monitoring etc. are lacking in most of the cases. A large number of elected representatives of PRIs are semi-literate or literate and know little about their roles and responsibilities, programs, procedures, systems. Often for want of good, relevant and periodic training, they are not able to perform their functions properly. Although all the district and intermediate panchayats are connected with computers, only around 20% Gram Panchayats reported to be having computing facility. In some states, village panchayats do not have any computing facility. Thank you so much for watching this video. If this video helped you in any way, so please do like and share this video and hit the subscribe button. M. Laxmikanth, Indian Polity. Chapter 39. Municipalities. The term urban local government in India signifies the governance of an urban area by the people through their elected representatives. The jurisdiction of an urban local government is limited to a specific urban area which is demarcated for this purpose by the state government. There are 8 types of urban local governments in India: municipal corporation, municipality, notified area committee, town area committee, cantonment board, township, port trust and special purpose agency. The system of urban government was constitutionalized through the 74th Constitutional Amendment Act of 1992. At the central level, the subject of urban local government is dealt with by the following 3 ministries. 1. Ministry of Housing and Urban Affairs. 2. Ministry of Defence in the case of cantonment boards. 3. Ministry of Home Affairs in the case of union territories. Evolution of urban bodies. Historical perspective. The institutions of urban local government originated and developed in modern India during the period of British rule. The major events in this context are as follows. 1. In 1688, the first municipal corporation in India was set up at Madras. 2. In 1726, the municipal corporations were set up in Bombay and Calcutta. 3. Lord Mayo's resolution of 1870 on financial decentralization visualized the development of local self-government institutions. 4. Lord Ripon's resolution of 1882 has been hailed as the Magna Carta of local self-government. He is called as the father of local self-government in India. 5. The Royal Commission on Decentralization was appointed in 1907 and it submitted its report in 1909. Its chairman was Hobhouse. 6. Under the diarchial scheme introduced in provinces by the Government of India Act of 1919, local self-government became a transferred subject under the charge of a responsible Indian minister. 7. In 1924, the Cantonments Act was passed by the central legislature. 8. Under the provincial autonomy scheme introduced by the Government of India Act of 1935, local self-government was declared a provincial subject. Committees and Commissions. The committees and commissions appointed by the central government to improve the functioning of urban local governments. Constitutionalization. In August 1989, the Rajiv Gandhi government introduced the 65th Constitutional Amendment Bill, i.e., Nagarpalika Bill, in the Lok Sabha. The bill aimed at strengthening and revamping the municipal bodies by conferring a constitutional status on them. Although the bill was passed in the Lok Sabha, it was defeated in the Rajya Sabha in October 1989 and hence lapsed. The National Front government under V.P. Singh introduced the revised Nagarpalika Bill in the Lok Sabha again in September 1990. However, the bill was not passed and finally lapsed due to the dissolution of the Lok Sabha. P.V. Narasimha Rao's government also introduced the Modified Municipalities Bill in the Lok Sabha in September 1991. It finally emerged as the 74th Constitutional Amendment Act of 1992 and came into force on 1 June 1993. 74th Amendment Act of 1992. This Act has added a new Part 9A to the Constitution of India. This part is entitled as the Municipalities and consists of provisions from Articles 243 p. to 243 ZG. In addition, the Act has also added a new 12th schedule to the Constitution. This schedule contains 18 functional items of municipalities. It deals with Article 243 W. The Act gave constitutional status to the municipalities. It has brought them under the purview of justiciable part of the Constitution. In other words, state governments are under constitutional obligation to adopt the new system of municipalities in accordance with the provisions of the Act. The Act aims at revitalizing and strengthening the urban governments so that they function effectively as units of local government. Salient features. The salient features of the Act are 3 types of municipalities. The Act provides for the constitution of the following 3 types of municipalities in every state. 1. A Nagar Panchayat, by whatever name called, for a transitional area. 2. A municipal council for a smaller urban area. 3. A municipal corporation for a larger urban area. But there is one exception. If there is an urban area where municipal services are being provided by an industrial establishment, then the governor may specify that area to be an industrial township. In such a case, a municipality may not be constituted. The governor has to specify a transitional area, a smaller urban area or a larger urban area, keeping in view the following factors. A. Population of the area. B. Density of the population therein. C. Revenue generated for local administration. D. Percentage of employment in non-agricultural activities. E. Economic importance. F. Such other factors as he may deem fit. Composition. All the members of a municipality shall be elected directly by the people of the municipal area. For this purpose, Each municipal area shall be divided into territorial constituencies to be known as wards. The state legislature may provide the manner of election of the chairperson of a municipality. It may also provide for the representation of the following persons in a municipality. 1. Persons having special knowledge or experience in municipal administration without the right to vote in the meetings of municipality. 2. The members of the Lok Sabha and the State Legislative Assembly representing constituencies that comprise wholly or partly the municipal area. 3. The members of the Rajya Sabha and the State Legislative Council registered as electors within the municipal area. 4. The chairpersons of committees other than wards committees. Wards committees. There shall be constituted a wards committee consisting of one or more wards within the territorial area of a municipality having population of 3 lakh or more. The state legislature may make provision with respect to the composition and the territorial area of a wards committee and the manner in which the seats in a wards committee shall be filled. Other committees. In addition to the wards committees, the state legislature is also allowed to make any provision for the constitution of other committees. The chairpersons of such committees may be made members of the municipality. Reservation of seats. The Act provides for the reservation of seats for the scheduled castes and the scheduled tribes in every municipality in proportion of their population to the total population in the municipal area. Further, it provides for the reservation of not less than 1/3 of the total number of seats for women, including the number of seats reserved for women belonging to the SCs and the STs. The state legislature may provide for the manner of reservation of offices of chairpersons in the municipalities for SCs, STs and women. It may also make any provision for the reservation of seats in any municipality or offices of chairpersons in municipalities in favor of backward classes. The reservation of seats as well as the reservation of offices of chairpersons in the municipalities for the scheduled castes and scheduled tribes shall cease to have effect after the expiration of the period specified in Article 334, which is presently 70 years, that is, till 2020. Duration of municipalities. The Act provides for a 5-year term of office for every municipality. However, it can be dissolved before the completion of its term. Further, the fresh elections to constitute a municipality shall be completed, a. before the expiry of its duration of 5 years, or b. in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. But, where the remainder of the period, for which the dissolved municipality would have continued, is less than 6 months, it shall not be necessary to hold any election for constituting the new municipality for such period. Moreover, a municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period for which the dissolved municipality would have continued had it not been so dissolved. In other words, a municipality reconstituted after premature dissolution does not enjoy the full period of 5 years but remains in office only for the remainder of the period. The Act also makes two more provisions with respect to dissolution. A. A municipality must be given a reasonable opportunity of being heard before its dissolution, and b. No amendment of any law for the time being in force shall cause dissolution of a municipality before the expiry of the 5 years term. Disqualifications. A person shall be disqualified for being chosen as or for being a member of a municipality if he is so disqualified, a. under any law for the time being in force for the purposes of elections to the legislature of the state concerned, or b. under any law made by the state legislature. However, No person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. Further, all questions of disqualifications shall be referred to such authority as the state legislature determines. State Election Commission. The superintendence, direction and control of the preparation of electoral rolls and the conduct of all elections to the municipalities shall be vested in the State Election Commission. The state legislature may make provision with respect to all matters relating to elections to the municipalities. Powers and functions. The state legislature may endow the municipalities with such powers and authority as may be necessary to enable them to function as institutions of self-government. Such a scheme may contain provisions for the devolution of powers and responsibilities upon municipalities at the appropriate level with respect to a. the preparation of plans for economic development and social justice, b. the implementation of schemes for economic development and social justice as may be entrusted to them, including those in relation to the 18 matters listed in the 12th schedule. Finances. The state legislature may a. authorize a municipality to levy, collect and appropriate taxes, duties, tolls and fees, b. assign to a municipality taxes, duties, tolls and fees levied and collected by state government, c. provide for making grants in aid to the municipalities from the consolidated fund of the state, and d. provide for constitution of funds for crediting all monies of the municipalities. Finance Commission. The Finance Commission, which is constituted for the panchayats, shall also, for every 5 years, review the financial position of municipalities and make recommendation to the governor as to 1. The principles that should govern a. the distribution between the state and the municipalities of the net proceeds of the taxes, duties, tolls and fees levied by the state and allocation of shares amongst the municipalities at all levels. b. the determination of the taxes, duties, tolls and fees that may be assigned to the municipalities. c. the grants in aid to the municipalities from the consolidated fund of the state. 2. the measures needed to improve the financial position of the municipalities. 3. any other matter referred to it by the governor in the interests of sound finance of municipalities. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the municipalities in the state, on the basis of the recommendations made by the Finance Commission of the state. Audit of accounts. The state legislature may make provisions with respect to the maintenance of accounts by municipalities and the auditing of such accounts. Application to Union Territories. The provisions of this part are applicable to the Union Territories. But the President may direct that they would apply to a Union Territory subject to such exceptions and modifications as he may specify. Exempted areas. The Act does not apply to the scheduled areas and tribal areas in the states. It shall also not affect the functions and powers of the Darjeeling Gorkha Hill Council of the West Bengal. However, the Parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modifications as it may specify. District Planning Committee. Every state shall constitute at the district level a district planning committee to consolidate the plans prepared by panchayats and municipalities in the district and to prepare a draft development plan for the district as a whole. The state legislature may make provisions with respect to the following. 1. The composition of such committees. 2. The manner of election of members of such committees. 3. The functions of such committees in relation to district planning, and 4. The manner of the election of the chairpersons of such committees. The Act lays down that 4/5 of the members of a district planning committee should be elected by the elected members of the district panchayat and municipalities in the district from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the rural and urban populations in the district. The chairperson of such committee shall forward the development plan to the state government. In preparing the draft development plan, a district planning committee shall a. have regard to 1. matters of common interest between the panchayats and the municipalities including spatial planning, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. 2. The extent and type of available resources whether financial or otherwise, and b. consult such institutions and organizations as the governor may specify. Metropolitan Planning Committee. Every metropolitan area shall have a metropolitan planning committee to prepare a draft development plan. The state legislature may make provisions with respect to the following. 1. The composition of such committees. 2. The manner of election of members of such committees. 3. The representation in such committees of the central government, state government and other organizations. 4. The functions of such committees in relation to planning and coordination for the metropolitan area, and 5. The manner of election of chairpersons of such committees. The Act lays down that 2/3 of the members of a metropolitan planning committee should be elected by the elected members of the municipalities and chairpersons of the panchayats in the metropolitan area from amongst themselves. The representation of these members in the committee should be in proportion to the ratio between the population of the municipalities and the panchayats in that metropolitan area. The chairpersons of such committees shall forward the development plan to the state government. In preparing the draft development plan, a metropolitan planning committee shall a. have regard to 1. the plans prepared by the municipalities and the panchayats in the metropolitan area. 2. Matters of common interest between the municipalities and the panchayats, including coordinated spatial planning of the area, sharing of water and other physical and natural resources, the integrated development of infrastructure and environmental conservation. 3. The overall objectives and priorities set by the Government of India and the Government of the state. 4. The extent and nature of investments likely to be made in the metropolitan area by agencies of the Government of India and of the Government of the state and other available resources whether financial or otherwise, and b. consult such institutions and organizations as the governor may specify. Continuance of existing laws and municipalities. All the state laws relating to municipalities shall continue to be in force until the expiry of 1 year from the commencement of this Act. In other words, the states have to adopt the new system of municipalities based on this Act within the maximum period of 1 year from 1st June 1993, which is the date of commencement of this Act. However, all municipalities existing immediately before the commencement of this Act shall continue till the expiry of their term, unless dissolved by the state legislature sooner. Bar to interference by courts in electoral matters. The Act bars the interference by courts in the electoral matters of municipalities. It declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be questioned in any court. It further lays down that no election to any municipality is to be questioned except by an election petition presented to such authority and in such manner as provided by the state legislature. 12th Schedule. It contains the following 18 functional items placed within the purview of municipalities. 1. Urban planning including town planning. 2. Regulation of land use and construction of buildings. 3. Planning for economic and social development. 4. Roads and bridges. 5. Water supply for domestic, industrial and commercial purposes. 6. Public health, sanitation, conservancy and solid waste management. 7. Fire services. 8. Urban forestry, protection of the environment and promotion of ecological aspects. 9. Safeguarding the interests of weaker sections of society, including the handicapped and mentally retarded. 10. Slum improvement and upgradation. 11. Urban poverty alleviation. 12. Provision of urban amenities and facilities such as parks, gardens, playgrounds. 13. Promotion of cultural, educational and aesthetic aspects. 14. Burials and burial grounds, cremations and cremation grounds and electric crematoriums. 15. Cattle ponds, prevention of cruelty to animals. 16. Vital statistics including registration of births and deaths. 17. Public amenities including street lighting, parking lots, bus stops and public conveniences. And 18. Regulation of slaughterhouses and tanneries. Types of urban governments. The following 8 types of urban local bodies are created in India for the administration of urban areas. Municipal corporation, municipality, notified area committee, town area committee, cantonment board, township, port trust, special purpose agency. 1. Municipal corporation. Municipal corporations are created for the administration of big cities like Delhi, Mumbai, Kolkata, Hyderabad, Bangalore and others. They are established in the states by the acts of the concerned state legislatures and in the union territories by the acts of the Parliament of India. There may be one common act for all the municipal corporations in a state or a separate act for each municipal corporation. A municipal corporation has 3 authorities, namely, the council, the standing committees and the commissioner. The council is the deliberative and legislative wing of the corporation. It consists of the councillors directly elected by the people, as well as a few nominated persons having knowledge or experience of municipal administration. In brief, the composition of the council including the reservation of seats for SCs, STs and women is governed by the 74th Constitutional Amendment Act. The council is headed by a mayor. He is assisted by a deputy mayor. He is elected in a majority of the states for a 1-year renewable term. He is basically an ornamental figure and a formal head of the corporation. His main function is to preside over the meetings of the council. The standing committees are created to facilitate the working of the council, which is too large in size. They deal with public works, education, health, taxation, finance and so on. They take decisions in their fields. The municipal commissioner is responsible for the implementation of the decisions taken by the council and its standing committees. Thus, he is the chief executive authority of the corporation. He is appointed by the state government and is generally a member of the IS. 2. Municipality. The municipalities are established for the administration of towns and smaller cities. Like the corporations, they are also set up in the states by the acts of the concerned state legislatures and in the union territory by the acts of the Parliament of India. They are also known by various other names like municipal council, municipal committee, municipal board, borough municipality, city municipality and others. Like a municipal corporation, a municipality also has 3 authorities, namely the council, the standing committees and the chief executive officer. The council is the deliberative and legislative wing of the municipality. It consists of the councillors directly elected by the people. The council is headed by a president-chairman. He is assisted by a vice-president vice-chairman. He presides over the meetings of the council. Unlike the mayor of a municipal corporation, he plays a significant role and is the pivot of the municipal administration. Apart from presiding over the meetings of the council, he enjoys executive powers. The standing committees are created to facilitate the working of the council. They deal with public works, taxation, health, finance and so on. The Chief Executive Officer, Chief Municipal Officer, is responsible for day-to-day general administration of the municipality. He is appointed by the state government. 3. Notified Area Committee. A notified area committee is created for the administration of two types of areas, a fast-developing town due to industrialization and a town which does not yet fulfill all the conditions necessary for the constitution of a municipality, but which otherwise is considered important by the state government. Since it is established by a notification in the Government Gazette, it is called as Notified Area Committee. Though it functions within the framework of the State Municipal Act, only those provisions of the Act apply to it which are notified in the Government Gazette by which it is created. It may also be entrusted to exercise powers under any other Act. Its powers are almost equivalent to those of a municipality. But unlike the municipality, it is an entirely nominated body, that is, all the members of a notified area committee including the chairman are nominated by the state government. Thus, it is neither an elected body nor a statutory body. 4. Town Area Committee. A town area committee is set up for the administration of a small town. It is a semi-municipal authority and is entrusted with a limited number of civic functions like drainage, roads, street lighting, and conservancy. It is created by a separate act of a state legislature. Its composition, functions and other matters are governed by the Act. It may be wholly elected or wholly nominated by the state government or partly elected and partly nominated. 5. Cantonment Board. A cantonment board is established for municipal administration for civilian population in the cantonment area. It is set up under the provisions of the Cantonments Act of 2006, a legislation enacted by the central government. It works under the administrative control of the Defence Ministry of the central government. Thus, unlike the above four types of urban local bodies, which are created and administered by the state government, a cantonment board is created as well as administered by the central government. The Cantonments Act of 2006 was enacted to consolidate and amend the law relating to the administration of cantonments with a view to impart greater democratization, improvement of their financial base to make provisions for developmental activities and for matters connected with them. This Act has repealed the Cantonments Act of 1924. At present, 2019, there are 62 cantonment boards in the country. They are grouped into 4 categories on the basis of the civil population. A cantonment board consists of partly elected and partly nominated members. The elected members hold office for a term of 5 years, while the nominated members, i.e., ex officio members, continue so long as they hold the office in that station. The military officer commanding the station is the ex officio president of the board and presides over its meetings. The vice president of the board is elected by the elected members from amongst themselves for a term of 5 years. The Category I Cantonment Board consists of the following members. 1. A military officer commanding the station. 2. An executive engineer in the cantonment. 3. A health officer in the cantonment. 4. A first-class magistrate nominated by the district magistrate. 5. 3 military officers nominated by the officer commanding the station. 6. 8 members elected by the people of the cantonment area. 7. Chief Executive Officer of the Cantonment Board. The functions performed by a cantonment board are similar to those of a municipality. These are statutorily categorized into obligatory functions and discretionary functions. The sources of income includes both tax revenue and non-tax revenue. The executive officer of the Cantonment Board is appointed by the President of India. He implements all the resolutions and decisions of the board and its committees. He belongs to the central cadre established for the purpose. 6. Township. This type of urban government is established by the large public enterprises to provide civic amenities to its staff and workers who live in the housing colonies built near the plant. The enterprise appoints a town administrator to look after the administration of the township. He is assisted by some engineers and other technical and non-technical staff. Thus, the township form of urban government has no elected members. In fact, it is an extension of the bureaucratic structure of the enterprises. 7. Port Trust. The port trusts are established in the port areas like Mumbai, Kolkata, Chennai and so on for two purposes: A. To manage and protect the ports, and B. To provide civic amenities. A port trust is created by an Act of Parliament. It consists of both elected and nominated members. Its chairman is an official. Its civic functions are more or less similar to those of a municipality. 8. Special Purpose Agency. In addition to these 7 area-based urban bodies or multipurpose agencies, the states have set up certain agencies to undertake designated activities or specific functions that legitimately belong to the domain of municipal corporations or municipalities or other local urban governments. In other words, these are function-based and not area-based. They are known as single-purpose, unipurpose or special-purpose agencies or functional local bodies. Some such bodies are: 1. Town Improvement Trusts. 2. Urban Development Authorities. 3. Water Supply and Sewerage Boards. 4. Housing Boards. 5. Pollution Control Boards. 6. Electricity Supply Boards. 7. City Transport Boards. These functional local bodies are established as statutory bodies by an act of state legislature or as departments by an executive resolution. They function as autonomous bodies and deal with the functions allotted to them independently of the local urban governments, that is, municipal corporations or municipalities and so forth. Thus, they are not subordinate agencies of the local municipal bodies. Municipal personnel. There are 3 types of municipal personnel systems in India. The personnel working in the urban governments may belong to any one or all the 3 types. These are: 1. Separate personnel system. Under this system, each local body appoints, administers, and controls its own personnel. They are not transferable to other local bodies. It is the most widely prevalent system. This system upholds the principle of local autonomy and promotes undivided loyalty. 2. Unified personnel system. In this system, the state government appoints, administers, and controls the municipal personnel. In other words, statewide services, cadre, are created for all the urban bodies in the state. They are transferable between the local bodies in the state. This system is prevalent in Andhra Pradesh, Tamil Nadu, Uttar Pradesh, Rajasthan, Madhya Pradesh and so on. 3. Integrated personnel system. Under this system, the personnel of the state government and those of the local bodies form part of the same service. In other words, the municipal personnel are the members of the state services. They are transferable not only between the local bodies in the state but also between local bodies and departments of state government. Thus, there is no distinction between local civil service and state civil service. This system is prevalent in Odisha, Bihar, Karnataka, Punjab, Haryana and others. The various national-level institutions providing training to the municipal personnel are 1. All India Institute of Local Self-Government, Mumbai, constituted in 1927. It is a private registered society. 2. Center for Urban and Environmental Studies, New Delhi, set up in 1967 on the recommendation of Nuruddin Ahmad Committee on Training of Municipal Employees, 1963 to 1965. 3. Regional Centers for Urban and Environmental Studies, Kolkata, Lucknow, Hyderabad and Mumbai, set up in 1968 on the recommendation of Nuruddin Ahmad Committee on Training of Municipal Employees, 1963 to 1965. 4. National Institute of Urban Affairs, established in 1976. 5. Human Settlement Management Institute, established in 1985. Municipal Revenue. There are 5 sources of income of the urban local bodies. These are as follows. 1. Tax revenue. The revenue from the local taxes include property tax, entertainment tax, taxes on advertisements, professional tax, water tax, tax on animals, lighting tax, pilgrim tax, market tax, toll on new bridges, octroi and so on. In addition, the municipal bodies imposes various cesses like library cess, education cess, beggary cess and so on. Octroi, i.e., taxes on the entry of goods into a local area for consumption, use or sale therein, has been abolished in most of the states. Property tax is the most important tax revenue. 2. Non-tax revenue. This source include rent on municipal properties, fees and fines, royalty, profits and dividends, interest, user charges and miscellaneous receipts. The user charges, i.e., payment for public utilities, include water charges, sanitation charges, sewerage charges and so on. 3. Grants. These include the various grants given to municipal bodies by the central and state governments for several development programs, infrastructure schemes, urban reform initiatives and so on. 4. Devolution. This consists of the transfer of funds to the urban local bodies from the state government. This devolution is made on the basis of the recommendations of the State Finance Commission. 5. Loans. The urban local bodies raise loans from the state government as well as financial institutions to meet their capital expenditure. They can borrow from the financial institutions or other bodies only with the approval of the state government. Central Council of Local Government. The Central Council of Local Government was set up in 1954. It was constituted under Article 263 of the Constitution of India by an order of the President of India. Originally, it was known as the Central Council of Local Self-Government. However, the term self-government was found to be superfluous and hence was replaced by the term government in the 1980s. Till 1958, it dealt with both urban as well as rural local governments, but after 1958 it has been dealing with matters of urban local government only. The Council is an advisory body. It consists of the Minister for Urban Development in the Government of India and the Ministers for Local Self-Government in states. The Union Minister acts as the Chairman of the Council. The Council performs the following functions with regard to local government. 1. Considering and recommending the policy matters. 2. Making proposals for legislation. 3. Examining the possibility of cooperation between the centre and the states. 4. Drawing up a common program of action. 5. Recommending central financial assistance. 6. Reviewing the work done by the local bodies with the central financial assistance. Thank you so much for watching this video. If this video helped you in any way, so please do like and share this video and hit the subscribe button. M. Laxmikanth, Indian Polity. Chapter 40. Union Territories. Under Article 1 of the Constitution, the territory of India comprises three categories of territories: A. Territories of the states, B. Union territories, and C. Territories that may be acquired by the Government of India at any time. At present, there are 29 states, 7 union territories, and no acquired territories. The states are the members of the federal system in India and share a distribution of power with the center. The union territories, on the other hand, are those areas which are under the direct control and administration of the central government. Hence, they are also known as centrally administered territories. In this way, existence of these territories constitutes a conspicuous departure from federalism in India. The Government of India is plainly unitary in so far as the relationship between New Delhi and these central enclaves is concerned. Creation of Union Territories. During the British rule, certain areas were constituted as scheduled districts in 1874. Later, they came to be known as Chief Commissioners' Provinces. After independence, they were placed in the category of Part C states and Part D territories. In 1956, they were constituted as the Union Territories by the 7th Constitutional Amendment Act, 1956, and the States Reorganization Act, 1956. Gradually, some of these union territories have been elevated to statehood. Thus, Himachal Pradesh, Manipur, Tripura, Mizoram, Arunachal Pradesh and Goa, which are states today, were formerly union territories. On the other hand, the territories that were acquired from the Portuguese, Goa, Daman and Diu, and Dadra and Nagar Haveli, and the French, Puducherry, were constituted as the union territories. At present, there are 9 union territories. They are, along with the year of creation, 1. Andaman and Nicobar Islands 1956, 2. Delhi 1956, 3. Lakshadweep 1956, 4. Dadra and Nagar Haveli 1961, 5. Daman and Diu 1962, 6. Puducherry 1962, 7. Chandigarh 1966, 8. Jammu and Kashmir 2019 and 9. Ladakh 2019. Till 1973, Lakshadweep was known by the name of Lakkadiv, Minicoy and Amindivi Islands. In 1992, Delhi was redesignated as the National Capital Territory of Delhi. Till 2006, Puducherry was known as Pondicherry. The union territories have been created for a variety of reasons. These are mentioned below. 1. Political and administrative consideration, Delhi and Chandigarh. 2. Cultural distinctiveness, Puducherry, Dadra and Nagar Haveli, and Daman and Diu. 3. Strategic importance, Andaman and Nicobar Islands and Lakshadweep. 4. Special treatment and care of the backward and tribal people, Mizoram, Manipur, Tripura and Arunachal Pradesh, which later became states. In 2019, the erstwhile state of Jammu and Kashmir was bifurcated into 2 separate union territories, namely, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. While introducing the Jammu and Kashmir Reorganization Bill, 2019, in the Parliament, the central government gave the following reasons for the creation of these 2 new union territories. 1. The Ladakh division of the state of Jammu and Kashmir has a large area but is sparsely populated with a very difficult terrain. There has been a long pending demand of people of Ladakh to give it the status of a union territory to enable them to realize their aspirations. The Union Territory of Ladakh will be without a legislature. 2. Further, keeping in view the prevailing internal security situation, fueled by cross-border terrorism in the existing state of Jammu and Kashmir, a separate Union Territory for Jammu and Kashmir is being created. The Union Territory of Jammu and Kashmir will be with a legislature. Administration of Union Territories. Articles 239 to 241 in Part 8 of the Constitution deal with the Union Territories. Even though all the Union Territories belong to one category, there is no uniformity in their administrative system. Every Union Territory is administered by the President acting through an administrator appointed by him. An administrator of a Union Territory is an agent of the President and not head of state like a governor. The President can specify the designation of an administrator. It may be Lieutenant Governor or Chief Commissioner or Administrator. At present, it is Lieutenant Governor in the case of Delhi, Puducherry, Andaman and Nicobar Islands, Jammu and Kashmir and Ladakh, and Administrator in the case of Chandigarh, Dadra and Nagar Haveli, Daman and Diu and Lakshadweep. The President can also appoint the Governor of a state as the administrator of an adjoining Union Territory. In that capacity, the Governor is to act independently of his Council of Ministers. The Union Territories of Puducherry in 1963, Delhi in 1992 and Jammu and Kashmir in 2019 are provided with a Legislative Assembly and a Council of Ministers headed by a Chief Minister. The remaining 6 Union Territories do not have such popular political institutions. But the establishment of such institutions in the Union Territories does not diminish the supreme control of the President and Parliament over them. The Parliament can make laws on any subject of the 3 lists, including the state list, for the Union Territories. This power of Parliament also extends to Puducherry, Delhi and Jammu and Kashmir, which have their own local legislatures. This means that the legislative power of Parliament for the Union Territories on subjects of the state list remain unaffected even after establishing a local legislature for them. But the Legislative Assembly of Puducherry can also make laws on any subject of the state list and the concurrent list. Similarly, the Legislative Assembly of Delhi can make laws on any subject of the state list except public order, police and land, and the concurrent list. Likewise, the Legislative Assembly of Jammu and Kashmir can make laws on any subject of the state list except public order and police and the concurrent list. The President can make regulations for the peace, progress and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu and Ladakh. In the case of Puducherry also, the President can legislate by making regulations but only when the Assembly is suspended or dissolved. A regulation made by the President has the same force and effect as an Act of Parliament and can also repeal or amend any Act of Parliament in relation to these Union Territories. The Parliament can establish a High Court for a Union Territory or put it under the jurisdiction of the High Court of adjacent state. Delhi is the only Union Territory that has a High Court of its own since 1966. The Bombay High Court has got jurisdiction over 2 Union Territories, Dadra and Nagar Haveli and Daman and Diu. Andaman and Nicobar Islands, Chandigarh, Lakshadweep and Puducherry are placed under the Calcutta, Punjab and Haryana, Kerala and Madras High Courts respectively. The Jammu and Kashmir High Court is the common High Court for the 2 Union Territories of Jammu and Kashmir and Ladakh. The Constitution does not contain any separate provisions for the administration of acquired territories. But the constitutional provisions for the administration of Union Territories also apply to the acquired territories. Special provisions for Delhi. The 69th Constitutional Amendment Act of 1991 provided a special status to the Union Territory of Delhi and redesignated it the National Capital Territory of Delhi and designated the Administrator of Delhi as the Lieutenant, Lt. Governor. It created a legislative assembly and a council of ministers for Delhi. Previously, Delhi had a metropolitan council and an executive council. The strength of the assembly is fixed at 70 members, directly elected by the people. The elections are conducted by the Election Commission of India. The assembly can make laws on all the matters of the state list and the concurrent list except the three matters of the state list, that is, public order, police and land. But the laws of Parliament prevail over those made by the assembly. The strength of the Council of Ministers is fixed at 10% of the total strength of the assembly, that is, 1 chief minister and 6 other ministers. The chief minister is appointed by the president, not by the LT governor. The other ministers are appointed by the president on the advice of the chief minister. The ministers hold office during the pleasure of the president. The Council of Ministers is collectively responsible to the Assembly. The Council of Ministers headed by the Chief Minister aid and advise the LT Governor in the exercise of his functions except in so far as he is required to act in his discretion. In the case of difference of opinion between the LT Governor and his ministers, the LT Governor is to refer the matter to the President for decision and act accordingly. When a situation arises in which the administration of the territory cannot be carried on in accordance with the above provisions, the President can suspend their above provisions operation and make the necessary incidental or consequential provisions for administering the territory. In brief, in case of failure of constitutional machinery, the President can impose his rule in the territory. This can be done on the report of the LT Governor or otherwise. This provision resembles Article 356, which deals with the imposition of President's rule in the states. The LT Governor is empowered to promulgate ordinances during recess of the Assembly. An ordinance has the same force as an act of the Assembly. Every such ordinance must be approved by the Assembly within 6 weeks from its reassembly. He can also withdraw an ordinance at any time. But he cannot promulgate an ordinance when the Assembly is dissolved or suspended. Further, no such ordinance can be promulgated or withdrawn without the prior permission of the President. Advisory Committees of Union Territories. Under the Government of India, Allocation of Business, Rules 1961, Ministry of Home Affairs is the nodal ministry for all matters of Union Territories relating to legislation, finance and budget, services and appointment of Lieutenant Governors and Administrators. All the 6 UTs without legislature, Andaman and Nicobar Islands, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, Lakshadweep and Ladakh, have the Forum of Home Ministers Advisory Committee, HMAC, Administrators Advisory Committee, AAC. While HMAC is chaired by the Union Home Minister, AAC is chaired by the Administrator of the concerned UTs. The Member of Parliament and elected members from the local bodies e.g. District Panchayats and Municipal Council of the respective UTs are members of these committees among others. The committee discusses the general issues relating to social and economic development of the UTs. Thank you so much for watching this video. If this video helped you in any way, so please do like and share this video and hit the subscribe button.